Good afternoon, ladies and gentlemen. The Appellate Division, First Department, is now in session. My first order of business will be to call the calendar. When you hear your case called, please state your appearance, and then I will reconfirm the oral argument time that's been allotted to you. Let's begin with People versus Almeida, submitted. Martinez versus City of New York.
Defendant Appellant.
And you've been allotted 5 minutes.
Thank
The
you.
other side is submitted.
Okay.
In the matter of T. Serenity, submitted. Hernandez versus Echampati.
Bradley A. Sachs, attorney for the appellant.
And you've been
Daniel
allotted.
Ratner.
Go ahead.
I'm sorry, Judge.
Go ahead.
Daniel Ratner, attorneys for the respondents.
Right, and the appellant has been allotted 5 and 2, respondent 5.
Thank you, Judge.
Gaston versus Trustees of Columbia University is submitted. Law offices of Mark Hellwheel versus Carambellas.
Michael Lanyata for the appellant.
Harry Littman for the respondent, Your Honor.
And the appellant's been allotted 5 and 2, the respondent 5. People versus Maximilian Nunez.
Anjali Pathmanathan for Mr. Nunez.
And Stephen Kress on behalf of the people.
The appellant is allotted 7 and 2, the people 7. Lynn versus 100 Wall Street.
Michael Altman for the appellant.
Rachel Camilleri on behalf of defendant respondents 100 Wall and Gant USA.
The appellant's allotted 5, the respondent 3.
Excuse me, Your Honor, I was told to request rebuttal time. When I was originally assigned time, there had not been a notice of appearance for the respondent.
There's no objection, Your Honor.
All right, I'll give you 1 minute in rebuttal.
Thank you, Your Honor.
In the matter of Lucia S., submitted. KS Trade versus International Gemological.
Hello.
Sally.
Good afternoon, Your Honor. Sorry.
But
Good afternoon. This is Michael
state who
Munoz
you
for
are.
appellants.
There is a problem with this one, so state who you are and who you're representing. Go ahead.
Thank you, Your Honor. This is Michael Munoz for appellants, International Gemological Institute, Gary Ehrenwald, and David Weinstein.
Sally Blinken for appellant Jerry Ehrenwald.
Michael Bedell for appellant Brody Copeland.
All right, so Ms. Blinken, I had given, and there is no appearance by the respondent who indicated they were going to submit. Ms. Blinken, after I allotted you some oral argument time based upon your request, and going back to the record, it appears that you have not submitted a brief, and you are not allowed to argue if you don't submit a brief. So I'm going to take that back. And also, so I'm going to withdraw my allotment of oral argument time to you.
That's fine.
Okay. There was, we'll leave it at that. Okay, so appellant, Mr. Munoz, you get 3, and appellant, Mr. Bedell for Brody, you get 3, and the other side is submit. Ramos versus Metro North.
Damian Cavallari, counsel for defendant appellant Metro North, and defendants cross respondents are the individuals Joe Strini, Justin Vonashek, and Gary Martens.
Do we have a respondent?
Mr. Fuchsberg's on mute. He'll be on in a second.
Sorry. Your Honor, this is Attorney Alan Fuchsberg, attorney for respondent as well as for cross appellant. And Your Honor, may I request 1 minute rebuttal time on the cross appeal, please?
I'll give you, all right. So I'm going to give the appellant 5 and 2, which is originally allotted. I'm going to give the respondent 5 originally allotted, and I'll allow you a 1-minute rebuttal. All right, the next two cases, Sung versus So, state appearances for the record.
Catherine Chestnut and Jason Advocate for the appellant, Your Honor. We have two separate appeals on today.
I know you do. Let me hear from the other person. We're going to get to it. I'll straighten it out.
For the plaintiff
Thank you.
respondent, I'm sorry, but for the plaintiff respondent, Sue Moss.
Okay. All right. There are two appeals, and they were filed by the same law firm. Subsequently to my assigning time, I heard that the appellant would like to have two attorneys argue the appeals. Is that correct?
Yes, that's correct. And I would reserve some of my time for my partner to offer a short argument on the second appeal.
The plaintiff respondent has no objection.
Right, and I have no objection to that either. It will be in the context of the 8 minutes that I gave you, and I would ask that you keep track of the time and split it up however you want to. Okay?
Thank you. Yes.
Thank you, Your Honor.
People versus Kevin Kareem.
Abigail Everett for appellant Kevin Kareem.
And Jennifer Westfall for the people.
All right, and the defendant gets 8 and 2, the people get 8. Eisenberg versus Weisbecker and Eisenberg versus Weisbecker and Eisenberg versus Rem. Those cases will be heard together. State your appearances.
Good afternoon, Your Honor. Daniel Coco for the plaintiff appellant. Request 6 minutes and reserve 2 for rebuttal, please.
And Bruce H. Letterman for the respondents.
Right, and the appellant has 6 and 2, the respondent 6. Alphys versus Smith. Do we have appearances?
Can you hear me?
I can hear somebody now.
Robert Spinack for respondent.
Okay.
Hello?
Do we have appellant? Sarah Adam?
Yes, Your Honor. I'm sorry I was speaking, but I was muted. Sarah Adam on behalf of the defendant appellants.
All right, and you each have 5 minutes.
Thank you.
Elon versus Washington is submitted. Velez versus City of New York is submitted. All right, we're going to begin to call the cases, but I'm going to call the case of Alpha versus Smith out of turn. Justice Mendez has recused himself from consideration. Justice Kennedy is vouched in, and she will be joining us in just a minute, and we will begin the argument. Okay, and Justice Kennedy, I see she's joined us, but she's muted. Excellent. All right, so the appellant.
I'll leave now.
Go ahead, thank you.
Yes, good afternoon, Your Honors. Sarah Adam on behalf of the defendant appellants. We're here on the appeal of a denial of the motion to dismiss of plaintiff's 4th amended complaint. The claims in the complaint found in legal malpractice, and there are
getting some
major
feedback. Smith, Miss Adam.
Yes, Your Honor. I do hear the feedback.
We're all living with the electronic world. Go ahead. I'll start your time again.
Speaker down and maybe we'll reduce the feedback.
Yeah. I'll start your time again. Go ahead.
Thank you, Your Honor. The plaintiff's 4th amended complaint is a legal malpractice complaint, and there are 2 primary sets of facts that give rise to this claim. The defendant's representation of the entity, the Alphys Company, in a lawsuit entitled Kane versus the Alphys Company. That is one set of facts, and that litigation is in fact referenced in the engagement letter between the defendants, the counsel, and the Alphys Company. And the second set of facts underlying the fourth amended complaint relates to my client's alleged failure to respond to something called the withdrawal letter dated September 20th, 2012. And that was sent by counsel for the United Teamster Pension Fund to the entity, the Alphas Company, which was formerly one of the plaintiffs. That letter advised on September 20th, 2012, that the Alphas Company was liable for what's called withdrawal liability pursuant to the Multi-Employer Pension Plan Amendment Act. And that's the first argument I'd like to address with the court's permission. Our position is, I'm sorry, Your Honor.
No, I'm giving you permission.
Thank you. Our position is that the withdrawal letter is not within the scope of my client's representation of the Alphas Company. The first point is that it's nowhere to be found in the engagement letter. The engagement letter details 3 litigations for which my clients were being retained by the Alphas Company. The withdrawal letter is not listed or discussed. And the second point—
The withdrawal letter came afterwards, correct?
Your Honor, the withdrawal letter is dated September of 2012, and the engagement letter was signed on October of 2012.
But eventually, the withdrawal letter became a claim that was made in one of the litigations that was referenced in the retainer letter, wasn't it?
Yes, Your Honor, that's correct. And the point that we make on appeal is it's very important when the allegations relating to the withdrawal letter became a part of that litigation. The trial court below did reference the fact that allegations relating to the withdrawal letter did become a part of one of those litigations in the engagement letter. But what we point out is it didn't become a part of the complaint in that underlying litigation until after the 90-day window to respond to that letter had already expired. So our position is, how can the plaintiffs try to hold my clients liable for failing to challenge the withdrawal letter within the 90-day period? And the court's rationale is that this is based on the withdrawal letter being a part of the litigation. Well, the withdrawal letter didn't become a part of the litigation until after that 90-day window closed. And that is, respectfully, Your Honor, what our point is about what the trial court missed below. Is that by the time the withdrawal letter became a part of the underlying litigation referenced in the engagement letter, it was already too late for my clients to respond to it. And that amendment occurred on February 13th, 2013, as referenced on page 9 of the record. So the amendment was not made until after the 90-day period expired, because the withdrawal letter at issue is dated September of 2012. The 90-day period would have expired in December of 2012. The underlying complaint was not amended until February of 2013, 2 months later.
Okay, anything further?
Well, yes, Your Honor. We had 2 other points. With respect to our argument that individual Peter Alphas's damages are limited to the damages he suffered individually, we do not agree with the trial court's finding that Mr. Alphas as an individual is entitled to pursue the corporate claim of the Alphas Company of New York at this time in this action. We ask the court to hold that the subsequent assignment of this entity's claims to the individual Peter Alphas did not retroactively remedy the Alphas companies and Peter Alphas's lack of capacity to sue the defendants. There was a discussion of the assignment of the bankruptcy trustee of the entity's claim to Mr. Peter Alphas, but our position is that this occurred after the entity had already filed a complaint against my clients.
Right.
And that the assignment didn't retroactively.
Your time has expired.
Thank you, Your Honor.
All right, let's hear from Mr. Spinack.
Hi, can you hear me okay? Is everything?
I can.
Okay. So my response to that is that this is the most egregious case of malpractice. It's textbook case, and defendants have no defense and are grasping at straws at ridiculous arguments. The withdrawal letter was very much part of the underlying litigation. They got notice of it with a September 20th letter. They, in fact, in their own words, in the same retainer, in a separate case 6L, they opposed the underlying plaintiff's intervention and specifically referenced the withdrawal liability claim. Then they filed a notice of appearance in the underlying litigation on October 3rd, and on October 4th, they got another letter informing them of the withdrawal liability claim. And then they never even informed their client about the withdrawal liability claim. So, as the judge noted in the court below, as plaintiffs' retained attorneys, defendants owed a duty to represent all of plaintiffs' interests that in any way bore on the underlying litigation, even relating to issues about which plaintiffs may have been unaware. Those interests included the interests implicated in the withdrawal letter, and they cited the case of Macquarie Capital USA versus Morrison and Forrester. For them to deny that it was part of the litigation is absurd. They specifically say in the engagement letter that they were representing Peter Alphys and the Alphys Company in the Kane et al. Case. That means the entirety of the case. They didn't limit the scope of their representation in any way. And the court below acknowledged that. So that's to that point. And as far as the 90-day deadline, you know, even if taken everything that they said is true, Peter Alphys still could have filed for arbitration after the amended complaint was filed. And they didn't even, what's mind-boggling, they didn't even tell the client about an amended complaint. He hired them for a $12,000 claim, and then all of a sudden, 9 months later, it's $1.2 million without any knowledge or and bankrupted his company. It's absurd. Nobody in the profession could excuse such behavior. So even after they got the amended complaint, the plaintiff, Peter Alphys, still could have filed, demanded for arbitration. So the 90-day deadline thing is not true at all. And as far as standing, I mean, this court itself back in 2017 held that Peter Alphys had an individual claim, and the court below rightfully recognized the assignment of the corporate claim from the bankruptcy trustee to Peter Alphys. There's no argument.
Okay. Thank you.
Thank you, Your Honors.
Okay, the next case up will be Martinez. We're going to invite Justice Mendez to join us again.
Back.
Thank you. All right, on Martinez, we have Ms. Brown.
Yes.
Okay.
Yes. Good afternoon, Your Honors.
Proceed.
Linda Brown from Hersfeld and Rubin, representing the appellant, the Housing Authority. In this case, the plaintiff identified 3 different widely separated locations as the place where her accident occurred. She marked 3 different photos.
At least one of those, she said later, oh, I made a mistake, right?
Yes,
So can we really count that one against her?
Well, if you, it shows her confusion because when she had the chance to correct her statutory hearing testimony, she did not.
Counsel, I'm sorry to interrupt. This Justice Moulton. The confusion, isn't that just as Supreme Court found, simply grist for cross-examination?
Well, it shows her inability to identify what she allegedly tripped over.
Well, it's not like the defects were blocks apart. They were all in the same street corner, all in front of the same building.
They were several feet apart. They were very different in character. The plaintiff's own attorney has said several times in the respondent's brief that plaintiff was confused. She doesn't, she's not really able to pinpoint where she fell. It's not like she fell on a specific location and there were several cracks in that specific location. She picked 3 separate locations that are separated by several feet.
What do you mean by several?
Well, it's apparent from the photographs that appear at page 172 to 175.
Yeah,
that,
shows a terrible sidewalk.
Well, the
general
lower court
area with a terrible sidewalk.
The lower court did not agree. Said that in his opinion, it was not extremely broken up. He disagreed with the plaintiff's characterization of it. But the point remains that she said that in her testimony that she fell close to the building. But she marked an area that was close to the street as the location where she fell. There's 3 different locations that cannot be reconciled. And at her deposition, she insisted that Exhibit B showed the same condition as the location she newly marked on Exhibit G as the place where she fell, and the 2 locations cannot be reconciled. So she's correcting her testimony at her deposition, but there's still conflicts. It still can't be reconciled. And the plaintiff tried to depict her as being 72 years old.
Counsel, this is Judge Owen. Counsel, I didn't mean to interrupt. This is Judge Owen. The photograph, as Justice Mendez and Justice Moulton point out, it's a large swath of the area of the sidewalk that we're now trying to drill down to precisely where she fell. And you're pointing out that she's inconsistent as to where she fell. But can you agree that it's in the proximity of where it's not like she fell a block away and that she's saying that this is the block this is where she fell, right? I mean, we're talking about a matter of a few feet in terms of where she fell. I mean, it's all around the same zone area. Would you agree to that? I mean, now we're splitting hairs as to exactly where she fell. I mean, I don't know. When I fall, I'm not measuring exactly where I fell. Thank goodness I haven't fallen yet.
She circled Exhibit B. Was right next to the wall of the building.
I understand that, but it's still in the zone of the area. It's not like she circled an area that's a different wall from where she fell, right? I mean, we're talking the photograph is accurate, correct? I mean, you're not arguing that the photograph that we have in the record is accurate in terms of where the sidewalk, the busted up sidewalk or the defective sidewalk is, correct? That's the photograph we're relying on. Now it's a matter of where exactly did she fall within that photographed area, right? And then, like Justice Moulton said, that's going to be for the trier of fact to assess whether or not she's believable or not, correct?
Yeah, Counselor, this is the last question for you to answer because your time is up, so answer it.
Okay. But the Housing Authority has a right in its investigation to know where the claimed defect is. And this testimony came out, and the deposition was more than 2 years after the accident. And she kept changing her testimony, and it makes it impossible to investigate properly. And, you know, the housing authority doesn't even have to show prejudice, but I believe in this situation, the prejudice is obvious. She didn't pinpoint the location in her notice of claim, in the complaint, the bill of particulars. We asked for more information. She didn't give us a really precise feet location until 2016.
I think we understand your argument.
Okay, thank you very
Thank you.
much, Your Honors.
Hernandez versus Ichampati.
Good afternoon, Your Honor. This is Bradley Sachs for the appellant. This is a medical malpractice case, and I believe that it presents, I just want to start my timer. It presents a classic disagreement between experts as to what the facts are and what the different parties did at different times. The court appeared, we claim anyway, in its decision to credit the factual assertions of the defendant and the opinions of the defendant's experts over the plaintiff's expert. Specifically, the plaintiff was admitted on March 10th for a cholecystectomy.
Yeah, we're aware of many of the facts, so I don't want you to use a lot of your time for that. But certain of the facts are not contested. So your client, she had a 3 millimeter abrasion to the outer layer of her small intestine, correct?
No, by the time it was diagnosed, she had a full through and through perforation that was spilling intestinal contents. And
that was in the medical records?
Yes, that's the repair that was done on March 14th, showed a through and through 3 millimeter perforation. It was the plaintiff's position that during the course of the surgery, even if the injury to the bowel that we claim occurred during the course of the either dissection or manipulation of the tissues was only a partial injury, the injury was such that it necrosed over the ensuing day into a full-blown perforation, but that the serosal surface itself has a specific appearance when it's uninjured, and even a bruise or scrape of the serosal surface will make that surface appear differently, and that the surgeon needs to react accordingly. If you look at the operative report of March 14th, you'll see that a through and through 3 millimeter perforation was repaired, and that bowel contents were in fact spilling. Assuming that the surgeon missed the injury to the bowel, this plaintiff also did not have a normal postoperative course. The anticipated length of stay was only to be overnight. When on March 11th, she continued having elevated heart rates, which were grounds for her to be held from March 11th, and then that elevated heart rate or tachycardia continued on March 11th and 12th and 13th. And by the evening and that's where the facts start getting a little bit disputed, because we submitted a picture that the plaintiff took of her wound on March the 13th at a time when her wound was uncovered. And you can see from the picture in appendix page 394 that there's a gaping hole with no sutures. Now, prior to March 14th, the only reference to care of that wound was that the wound was opened and packed by the residents on the overnight of March 12th to March 13th. Now, there's no documented record of the, other than saying the wound was opened and packed. Each resident and Dr. Ichampati were then deposed, and each had a different interpretation of what the words open and packed mean to strain almost the use of the English language. Our expert pointed out that opened and packed had a very specific meaning. And if you look at the photograph at page 394 of the record, you will see an open wound which none of the defendants acknowledge existed, although they don't challenge that the photograph was taken when and under the circumstances that are described in the record.
Who took those photographs, counsel?
I'm sorry, Your Honor?
Who took those photographs?
My client took that photograph because she was unable to see what had been done with her. So while she was in the hospital, she took her camera and held it so she could see what was going on in her abdomen.
That's when the overnight crew was basically doing the cleaning and the packing of the wound.
Yes. And the
And just to follow up, and that was what date?
That's March 13th.
When she took the picture?
When she took the picture. And it's at that point, Dr. Patty still claims that the wound was clean, dry, and intact when he examined her on the evening of March 13th. And nobody acknowledges.
I'm going to ask you to wrap up your argument because your time is up. Right.
Well, thank you, Your Honor.
Okay. Go ahead.
Good afternoon, Your Honor. This is Dan Ratner from Heidel, Petoni, Murphy, and Bach. So what happened here was that plaintiff's expert failed to address a very specific point that was made by our expert at pages 70 and 71 of the record, where he offered an opinion that, you know, there could be a traction injury, a slow developing thing that is not visible at the time of the surgery itself. So yes, counsel mentioned that there was a 3 millimeter through and through wound when it was diagnosed, but at the time of the procedure itself, what may or may not have happened would be a small bruise that was could not have been apparent as an injury. There was no bleeding, there was no bile, none of those things. No one disputes the fact that my client did a visible inspection of the area at the time and didn't see anything. And plaintiff's expert failed to respond to our expert's theory that not only at the time of the surgery was there no visible wound, but also that Ms. Hernandez's course after the procedure was not consistent with a through and through perforation.
What about the counsel? What about the fact that she was experiencing tachycardia, which is one of the arguments that they make, that should have alerted the treating doctor that something was wrong?
Well, that is correct, but there also would have needed to be some signs of bleeding, some signs of bile. Those are the sorts of things. And in reference to this issue of the open and packing of the wound and the photograph, the resident that was involved in the treatment specifically testified that the meaning of that is that you simply look at the dressing and you replace it. But there was no evidence that it had been packed with any gauze, which would be the telltale thing the thing that you would do if there was some evidence of infection. And that was specifically testified to at pages 358 through 362.
Don't her simultaneous pictures of the material that was coming from the wounds, aren't they indicative of infection, sufficient to at least create an issue of fact about whether appropriate action was taken here?
Well, the thing was that there was no evidence of any bile or bleeding at that point.
Well, there was some brown liquid being oozed from the wound, wasn't there?
A small amount, that our expert testified that in and of itself was not enough to evidence any kind of an infection at that point in time. So that's what really happened here. But the most important...
So just to clarify for me, because I may have been under a misapprehension. So the was ultimately operated on, which was taken in for the corrective surgery, and they discovered that there was a perforation. What was that perforation? Was it a through and through?
At that point, of course, yes. Yes.
Not of course, but okay.
No, you're right. I'm sorry, Judge. I didn't
and what was its size?
3 millimeters. But at that point, there was no evidence of that particular wound at the time of the initial gallbladder removal surgery. The point is that it was an unavoidable complication of this type of surgery that can happen in the absence of malpractice. And that's what plaintiff's expert failed to rebut in opposition to our motion.
I don't think the claim, the claim as I understand it on appeal is not that a perforation occurred, which apparently is a risk of the surgery when he was licensing the adhesions, but that it wasn't discovered at the time or intraoperatively and then not appropriately discovered after post-op. That's how I understand the claim, and that's something different, isn't it?
Right. And our point is that it was not discoverable at the time of the procedure. That's the position that we took below, and which plaintiff failed to rebut below. That's the problem. As for the subsequent care and the delay in making the diagnosis, our position is that there were no telltale signs, that the photograph standing alone did not evidence that the interpretation of the record that there must have been gauze put in there to deal with an infection early on was not borne out by the testimony in the record. So that's what we're saying.
Okay, thank you.
Your Honor.
All right, rebuttal?
Yes, just briefly, Your Honor. What I think is highlighted is there's no record of anybody removing sutures from that wound. The operative report of March 10th, when the doctor did his initial gallbladder surgery, shows that the skin was closed. The skin in the photograph taken March 13th is opened. And it's opened because on March 13th in the overnight, 12th to 13th, the residents came in, opened the wound because there was brown drainage, packed the wound, and you can see in the photograph the red banding on either side, which our expert and which the court below ignored, called evidence of cellulitis. The court below called that evidence of redness. And
can I go back to the intraoperative claim?
Yes.
What facts that were in the medical record or otherwise facts that could be established did your expert rely on to conclude that the tear should have been discovered?
The basis for the opinion is that there's a specific appearance of serosal surface, and that even a bruise or injury to the surface will change its characteristic appearance.
Right, and I saw that, but where is it in the record that there was any change in the characteristic of the intestine at that time? There is in the operative notes, it does say that the doctor looked at the organs, didn't see blood, didn't see bile, and in fact, your expert says you'd see blood, but there was no blood, right? We can agree on that.
What my expert said, we can agree there was no bile or other material released, which would have been evidence of a through and through perforation at the time of the surgery. We're saying at the time of the surgery, the intestines, which were not part of the operative field, but had to be manipulated out of the way to get access to the gallbladder, when it was not inspected carefully, even though the doctor says that
isn't that opinion based on the fact that it's not really based on facts, it's based on the ultimate injury, and I'm not sure you can do that. You know, I don't think you can reason backwards. There has to be something in the record that would otherwise support a conclusion that there was some kind of trauma to the small intestine at that time.
I'll answer it the only way I can, which is obviously we don't have a video, which would be the only way to show whether the inspection was done carefully or not carefully. But more importantly, the patient became tachycardic, and tachycardia.
But that didn't come afterward.
That started on the first post-operative day. That's why they kept her beyond the 11th.
I'm talking intraoperative.
No, intraoperative would never happen. She's under general anesthesia and under control. Right. The body it takes time for the body to react. But by the 11th, she was tachycardic and had not achieved any of the milestones that would have been necessary to discharge her. So from a simple procedure which should have been an overnight hold at most, They kept her again because they couldn't explain the cause of the tachycardia.
Okay,
And
thank
that
you.
was that we say is evidence. Thank you very much, Your Honors.
Thank you. Okay, the law office of Hellweil against Karen Bellis.
Good afternoon, Your Honor.
Good afternoon.
May it please the court. This is an appeal from an order which granted summary judgment in favor of the plaintiff law firm against my client, who was a client of theirs in a divorce proceeding.
So here's the question, really, in this case, is that you sued for accounts dated, and that was what summary judgment was granted on. Did you, or did the even the defendant, or let me take it back.
Your Honor, I'm the defendant.
Did malpractice? Did it have to be addressed in this action? Did the issue of malpractice have any bearing on this action for accounts dated?
Absolutely, Your Honor. I believe the case law is clear that if a malpractice claim is intertwined with the claim for accounts stated, which it is.
How can we tell whether this is intertwined or not? It wasn't asserted in this case.
Well, it was certainly asserted as an affirmative defense.
Well, I assume you're relying on the eighth affirmative defense. The eighth affirmative defense didn't say malpractice. Let's start there. Correct?
It didn't use the word malpractice.
It didn't use the word deviation either.
Yes, but it did say that
that she didn't like the quality of his work.
I think it said a little bit more than that. I think it said that it didn't attain the standard of competency.
Yeah, but counsel, this is Judge Oing. The affirmative defense, the way I understand it, is interposed to respond against the account stated. And the record here clearly, at least Supreme Court found, that an account stated had been proven or established by the plaintiff. So that, in a sense, meant that the Supreme Court basically found that your affirmative defenses were without merit. I mean, that's essentially what it, because the affirmative defense goes right at the heart of the account stated. However you want to phrase it, or however you want to couch it, right?
Your Honor, I respectfully disagree. I believe that if you take a look at the court's decision, it addressed in very extensive detail the issues of mailing, the issues of receipt of the invoices. It did not address at all the affirmative defenses or the malpractice claim.
That's what I'm saying. Well, first of all, you can't say malpractice. It's only an affirmative defense. You have a malpractice, you have counterclaim. Okay, you have also a separate action too. I agree. So let me finish this. Well, the affirmative defenses, the way I understand affirmative defenses and how they work, is that they're used to assert or at least defend against the actual claim coming at you. And here, the account stated is the actual claim, the single claim coming at your client. So when Supreme Court, I mean, we can disagree about this, when Supreme Court found in favor of plaintiff, that sub silentio means that Supreme Court rejected all your affirmative defenses.
Well, Your Honor, just to clarify, there was a separate. First, let's start with this. There was certainly a separate malpractice case brought against the plaintiff.
After this action was commenced, correct?
After this action was commenced, yes. There were, and that malpractice case was premised upon the same complaints that my client had made throughout the course of the litigation about how her case was being handled.
Counsel, before you continue, when was that malpractice action filed?
You'll have to forgive me, Your Honor. I don't have the date right in front of me.
I think I saw something like January 21st, which would make it sort of like in response to the motion for summary judgment.
No. It was before the motion for summary judgment. It was clearly before the motion for summary judgment. But as I said, there's no mention of the malpractice defense or the malpractice action in the court's decision. And more importantly, there was absolutely no evidence whatsoever produced there was no evidence upon which the court could have relied on to say that there was no practice here.
whose burden was it to produce that evidence? I have to say, here's the procedural conundrum that I think this case raises. But your client made a strategic, or somebody made a strategic decision, rather than to assert this as a counterclaim, you asserted it in a separate action. And while ordinarily I would say, well, big deal, and as you said, gee, I could move to consolidate it, I don't think it's really that easy, because part of the problem is that the consolidation is not automatic. And consolidation depends on common questions of law and fact. And it sort of bears, but it's not completely synonymous with the intertwining. But given your client's representation and the time at which this law firm came in, I think that consolidation was not automatic. We can't assume it. And so why would we even deal with the malpractice in this case, since your client really chose to bring it in another case? Strategic. You had your reasons.
Your Honor, a couple of points. I think the case law, let's start with this. The case law, I think, makes clear that, let's say, if it was brought as a counterclaim, that the burden is on the plaintiff to establish a freedom from malpractice. That's number one. Number two, the malpractice complaint, even though it was a separate action, the malpractice complaint was included as an exhibit in opposition to the motion for summary judgment. So it should have been considered at that point. And again,
Counsel, let me stop you right there. This is Judge Owen. Let me stop you right there.
Sure.
So that you're saying that in all cases where there's a legal fees action commenced, that if you have a separate action, legal malpractice action, just percolating out there in the universe, that's enough then to thwart the law firm from collecting its fees. That's essentially what you're saying, right? You don't need a consolidation. As long as I got a standing legal malpractice action, that's enough.
Yes, I believe that's correct, because
but then how do you justify that, or how do you reconcile that with case law that says you need a counterclaim? You need a counterclaim to bring that in. So isn't that almost by logical extension that you need to consolidate a legal malpractice action too?
The case law does not say that you're required to have a counterclaim. It just so happens
like you just said, it just so happens that all the cases that I've seen and that have been cited and that I've looked at all deal with counterclaims. And in fact, one case even said that it was waived because they didn't file an answer amending the answer in time to assert a legal malpractice claim. So that would, to me, suggest that you need to have a counterclaim at a minimum, right, to do this intertwining analysis. So why can't that be extended to having a consolidate a legal malpractice action too?
Well, I think, Your Honor, I think if you do that, you're placing procedural form over substance. And, you know, as I said, in this case, the court had the complaint in front of it in the malpractice case, and the defendant had the plaintiff had the opportunity to submit their evidence that there was no malpractice here. The case that you're citing is a case in which
that's the Emory case.
And I believe in that case it wasn't just the fact that it was a counterclaim and that they amended the answer to bring it in. There was an issue there as to whether or not there was any merit to the malpractice claim. Here, I think, Your Honor, I think it's quite clear that there is merit to the malpractice claim. The malpractice claim.
I don't think there's anything in the record one way or the other about the merit of the malpractice claim. And that's honestly one of the things that we're kind of struggling with here. There's nothing to indicate that it's it has merit or not. It's just asserted, period.
Yes, Your Honor. There was a motion to dismiss in that case, which was included as part of the record here. A motion to dismiss that was made on behalf of the plaintiff in this case, who's the defendant in that case. The motion to dismiss was denied. They had an opportunity to get the malpractice case dismissed, and that motion was denied. So there is merit, and I do believe that.
When was that order made?
It was made during the pendency of this appeal. I believe it's included as part of the record.
It wasn't before the court at the time of the motion for counts summary judgment.
It hadn't
So
been
how could it
decided.
be part of this appeal?
Well, it's
All
part of
right,
the.
yeah, I would sure that. You're out of time. We'll hear from your adversary.
Thank you, Your Honor.
Yeah. Mr. Lippman.
Thank you, Your Honors. I'm going to address the points that were just discussed. The decision in order.
Actually, let me get at it a different way with you, though. There's the Glasser case, right? You're familiar with that case, right? It's out of this department. Does that put the burden on your client in an account stated to show freedom from malpractice?
There's no malpractice counterclaim in this case, Your Honor. Has been
I
established.
didn't ask you that. Did I ask you
Glasser's in-
that?
Sorry.
I didn't ask you that.
Well, Glasser
I
is
asked for your view of the Glasser case. Whose burden?
Glasser is inapplicable here because there's no counterclaim sounding in malpractice. There's an affirmative defense.
Your defense here, your argument here is just because there's no counterclaim, whether there's a separately commenced malpractice or not, and whether it has merit or not, is just not germane.
Well, we would argue that number one, it's not germane, and number two, in this case, it's particularly irrelevant, and I will explain why. If the court takes judicial notice of the decision by Justice Lewis Knock on the motion to dismiss the malpractice case, and it's a decision in order filed April 21, 2020, that judge described the malpractice claims as alleging that Mr. Hellweil failed to pursue a motion to compel, failed to pursue three motions to compel. Okay, basically failure to act. None of the counterclaim allegations has anything to do with the work that is reflected in the dozens of invoices at issue here. So there's no, even if the malpractice claim were a counterclaim, Ms. Carambellis couldn't prevail on her theory of defense because there's no intertwining of the allegations of the malpractice and the work that was done. In fact, if the malpractice claim, even if the allegations in the malpractice claim were correct, Your Honor, that would only mean that Mr. Hellweil should have done more work. He should have made all these motions to compel, and the invoices would only be larger. In other words, we have 100%.
No offense, Mr. Lippman, but that sounds a little sophistic to me. I mean, if an attorney is required to provide a sort of a baseline of services and they don't do it, you mean to me they should be paid for everything else that they've done, even if the results achieved are not appropriate, given the nature of the litigation?
The complaint
is that really true?
The malpractice complaint here, though, Judge, if you look at it, is not that the services that Mr. Hellweil actually
I understand your argument. I'm taking it to its conclusion. You're saying that a failure to act, if that's a basis of a malpractice, then legal fees are just due no matter what the outcome of the case was.
In the stated case, yes, the counterclaim sounding in malpractice, which it doesn't exist here, as we know, but even if it did, has to be intertwined. The case law is clear on that.
I understand, but what means intertwined? It's not enough that it just pertains to the period of time that your client was providing services to this client in the same action? Really?
Well, if that were the case, Your Honor, then the word intertwined would have virtually no meaning because of counterclaim.
I disagree with that, particularly in this case, where she had attorneys that preceded your client, and obviously for things that were done and strategic choices made by the prior attorneys, that has nothing to do with it.
So,
the time period.
So, Mr. Lippman, this is Judge Oring. Let me ask you this question. Let's deal with the facts that we have here. We have an account stated claim. We have an affirmative defense that whatever it says, let's argue that it's improper or inadequate representation. That's what we have. And we have separately a legal malpractice action. Those are the facts we have. So that your client moved for summary judgment on its account stated claim. Judge Giss is asking, does your client have the burden to prove known legal malpractice? Well, I guess in this case here, given the facts that we have just the count stated and affirmative defense, the answer should be no, right? Because there is nothing for you to, there's no other element for your client to have to prove in this case, right? To satisfy the account stated claim.
I think that is correct. And I would like also to, sorry.
And the next thing is that, and I pose this to the appellant, the Supreme Court, by its finding in favor of your client, essentially, without mentioning it, dismissed all the affirmative defenses.
Well, I would like to correct one thing, Judge. I totally agree with everything you just said, except the judge below did address the counterclaims, and Mr. Lognato.
The affirmative defenses. Don't say counterclaim. Affirmative.
I'm sorry. The affirmative defenses. You're right. The judge below did address them, and he said on the second page of his opinion, I'm sorry, third page, top of his opinion, a number of conclusory affirmative defenses. So he looked at them, and he looked at them as being conclusory. Now, if you look at the record at page 533 to 534 and read the eighth affirmative defense yourself, I think you will agree with the learned judge below that they're completely conclusory. So he did not give them any credibility. Meanwhile, the defendant in this case is permitted to pursue her malpractice claims in that case if it goes. If she gets a judgment, then there's an insurance company behind Mr. Helwile, and she'll be made whole. But I think that those counterclaims are not in this case.
I'm going to ask you wrap up your argument. Thank you. And we're going to hear rebuttal from Mr. Lognato.
Thank you, Your Honor.
Sir.
Well, I want to just make clear that whether or not the court dismissed the affirmative defense or not, if it did dismiss the affirmative defense, it had no basis for doing so. There was no evidence that no malpractice was committed. They didn't present any evidence on that issue at all. The court also erred taking a step back.
Counsel, this is Judge Oing. I want to seize on what you just said.
Yeah.
The affirmative defense is always the burden on the defendant. You just said that you just shifted over the burden to the plaintiff lawyer to prove your affirmative defense. You can't do that.
Your Honor, on summary judgment, respectfully, on summary judgment, the defendant may ultimately have the burden of establishing an affirmative defense. Right. But in order to get an affirmative defense dismissed, there's a burden on the moving party.
The question then, to turn the question around, then you can use the affirmative defense to raise a factual issue. That's your burden, right? Because if he proves prima facie that your affirmative defense should be all wiped out, then you got to come back now. Let's just arguably say that he proved prima facie that he carried his burden. All your affirmative defenses should be gone. Now it's your burden shifted back to raise a factual issue. Like that little, it's like a little ping pong game we're going here. I catch these things.
Your Honor, again, I think the burden is on them to have it dismissed.
I'm not arguing. I'm saying prima facie. Let's assume that he did prove the prima facie. Now it's your burden.
But my point is he didn't prove. There's no evidence at all on the record regarding.
That's my question. Okay, I got it.
Anyway, the other issue I want to bring up, taking a step back, is the court also, I believe, erred substantially on the issue of whether or not any complaints were made by the plaintiff in response to the bills. There were hundreds of pages of emails in which the defendant complained about the services that were provided by the plaintiff, instructions that were not followed. All of the substance of the malpractice case is set forth in all of the emails that my client, and there was emails, there were also verbal discussions in which my client complained about their failure to.
This is one last point I want to make. You still have your remedies. You still have a pending legal malpractice action against Mr. Helwile, correct? So it's not like you're out. It's not like you're without a remedy. You do have a remedy.
Well, I may have a legal remedy, but in reality, I may not. The insurance may not. Counsel mentioned the insurance on a malpractice. That may not cover the amount of the judgment that we're talking about here. I still think that the lower court erred on a number of issues, including, if complaints are raised in response to an account stated, that should be enough to knock out the account stated. The court also recognized that they didn't do regular mailings, that my client, they didn't establish that they did the mailings. They only, there's a paralegal put the bills in an outbox. There was no evidence of how it got from the outbox to the mailbox. There were a number of bills that even if
I know, and you're on rebuttal and you're way off time, but there was a point at which, they were fighting back and forth about whether she got the bills, and the office said, we keep sending you duplicates, you get them, you want them here, you want them there. But leaving that aside, at one point, the paralegal gives her the bills and said, sign a receipt for them so we don't have any further dispute. And that was essentially what the court relied on. So I think I understand the malpractice arguments, but I just don't understand that you really have any arguments on the bare bones account stated.
Your Honor, on that issue, and I'll just leave it with that.
Right.
That issue, that signature that she received the bills was not all of the bills. Even if you agree with that, there were approximately 10 bills that were never received. No proof that they were received at any point. That was one of the errors that the court made in relying entirely on that single document. Anyway, I'll wrap it here, and I thank you.
We're done. All right, we're done. Thank you both.
Understood. Thank you, Judge.
Okay. People versus Nunez.
Good afternoon, Your Honors. May it please the court, my name is Anjali Petmanathan on behalf of Mr. Nunez. Mr. Nunez was deprived of his right to a fair trial in this case, where the prosecution was permitted to repeatedly expose additional evidence of his girlfriend's family's drug trafficking offenses as purported background evidence. There was no probative value in exposing the jury to the Mercedes family's drug trafficking crimes or the narcotics trade in general.
Ms. Manthia, we're having trouble hearing you. Can you adjust your mic or?
Can you hear me any better?
Yep.
Yes.
Okay, I will lean closer. What I was saying, Your Honors, is that Mr. Nunez was never accused of being part of a narcotics conspiracy. He was not accused of any drug possession or any drug trafficking crimes. There's no evidence connecting him to his co-defendant's drug trafficking offenses.
Wasn't he seen, or didn't he register a vehicle in his name that belonged to the members of the conspiracy?
Your Honor, the evidence that came out at trial was a co-defendant, Ms. Waleska Fredera, saying that she registered Mr. Nunez's name in a car. But actually, that point brings up the very reason why this evidence should never have been admitted in Mr. Nunez's case.
Counsel, this is Judge John. I want to pivot onto the weapons charge, the conviction on the weapons charge. Why isn't it that the opening of the suppression hearing was improper? I mean, the statements were the same, weren't they, from the two individuals, the DEA agent and the detective?
The statements were not the same, Your Honor. More importantly, there was just no basis to reopen the hearing. At the end of the day, the prosecution is supposed to have one full, fair opportunity to litigate what they want to litigate in the suppression hearing. They chose to only bring one of their witnesses. The statement was a different statement to a different person in a different location. There just wasn't a basis. The court abused its discretion by allowing them to reopen the hearing when the prosecutor simply chose, out of convenience, presumably, to not put on all of their witnesses and all of their evidence.
Well, it was just one witness. It was not all. We're talking about one witness.
Your Honor, it's two separate witnesses who didn't open the same statements. But what's really important here is the fact of the matter is that there was no evidence that supported the fact that Mr. Nunez knowingly possessed this purported weapon. All he was an overnight guest in his girlfriend's apartment. There was no knowledge by the district attorney's office. What we have here is evidence that the DEA's agent, Agent Bach, searched systematically the closet, found a gun, and therefore couldn't use it, and did not have the key, wrapped in a towel inside of a closed black drawstring bag, in a shelf in a closet, behind clothing, purses, and items.
Counsel, you're going in and out again. This is Justice Moulton. I'm sorry, but I don't know. There's some strange feedback loop that's happening.
I'm sorry, Your Honors. I believe there's a phone call that's not muted. That may be the feedback. Can you hear me any better now?
It's better
Yes.
if you're closer to the computer. But let me ask you the question. There was some personal property found in the closet that did identify your client, the pill bottle, for example. Was it possible for the jury to draw an inference of possession from that and the fact, and of course, his presence in the apartment?
Your Honor, his presence is undisputed. The fact that his emergency medication was there is undisputed. The fact that he had 2 pieces of paper with his name on it in the apartment is undisputed. However, what's important to note is that those 2 pieces of paper prove that his address was not at that location. At the end of the day, all of that evidence only shows that Mr. Nunez was nothing more than an overnight guest in this apartment. And his mere presence is not enough to show that he knowingly possessed whatever his girlfriend had hidden in her closet. Ultimately, more is required, right? There is a presumption, but that presumption is weak. And in this case, it was directly rebutted by the defense's case. Ms. Waleska Fredera testified that she had never told Mr. Nunez this gun was in her closet. She had never seen him go anywhere near this bag or open this bag to have uncovered it. And we have testimony from the prosecution's office that said, from Agent Bach, that said that he could not tell a gun was in this bag when he first saw it, when he first uncovered it. So there was no plain view argument here. Ultimately, what we have is a man who was in a relationship with a person whose family was involved in drug trafficking crimes, who happened to stay overnight at her apartment. Unbeknownst to him, she had a gun in his closet. And as this court found in People versus Acosta, this type of verdict creates an unacceptably high risk of convicting and punishing a person who's innocent of the crime, where he's living 16 to life in prison.
Sit closer to the computer.
Closer.
Yeah.
That type of conviction can't rest on such weak evidence. And if I may just go back to the problematic drug crimes evidence that was introduced here, I wanted to be clear how much the jury heard about these drug crimes. This wasn't just background evidence. They learned that the DEA, the ICE agents, federal agents, New York City agents were all searching for this family for over 9 months, that they were following several members of the family, tracking their cars and homes, that they stopped them, arrested them, found $60,000 worth of heroin, found so much cash in these cars that one of the agents hurt his back carrying it. The agents were allowed to testify to drug trade items like kilo presses and how they are used to form bricks for drugs, vacuum sealers to package the drugs that are being trafficked, disposable phones and how they're used in these narcotics activities. All of this evidence was completely irrelevant to Mr. Nunez's, the allegations against him at trial. Ultimately, he was on trial for possession of a gun inside of his girlfriend's apartment. He was never connected to these drug activities. It's important to highlight that no drugs were actually found inside of the apartment in which he was arrested. He wasn't suspected of being part of this Mercedes family's drug enterprise, and he was never even known by the DEA agents who were following this family for months on end before he was arrested. Complete surprise that happened to be at the apartment. So the fact that all of this drug trafficking and uncharged crimes came into his case and was exposed to the jury essentially violated his self-standing right to a fair trial. And so the only remedy there is that at the very least, his conviction should be overturned and he should be ordered a new trial with the preclusion of that evidence, if Your Honors find that the verdict was not against the weight of the evidence, which would require dismissal. And I'll just reserve the rebuttal.
Thank you. Okay.
Good afternoon. May it please the court.
Go ahead.
Oh, thank you, Your Honor. Good afternoon. May it please
Good
the
afternoon.
court. So in order to prove the defendant guilty of possessing a gun, the people were required to prove that he had dominion and control over the area where the gun was found, such that he had the ability to use or dispose of the gun. Now, there is absolutely uncontested, overwhelming proof that he had dominion and control over the area where the gun was found, most specifically the closet. Even his girlfriend, Waleska Fredera, testified that he kept things in there. Clearly, he used the closet. There's just no way.
Didn't she also use the closet?
Yes, Your Honor.
I wasn't charged with the gun.
Your Honor, I believe she was originally charged with the gun, and she ultimately pleaded guilty to other crimes. And of course, possession is no less possession even if it is joint, which is one of the citations we have in our case. But I just don't think there's any real dispute that he had control over the closet. And so the question becomes, was there sufficient proof of knowledge? And I think the fact that he had a prescription pill bottle right next to, and that's a quote from the agent who did the search, right next to the bag containing the gun. He had his inhaler. He had a piece of mail with his name on it. Yes, it was at a different address, but it's his name on it. Other mail inside the closet. All of that, I think, gives rise to an inference that he knew that the gun was in the closet. And
what about the uncharged crimes that were elicited throughout the trial regarding this Mercedes family and their drug conspiracy?
I'm sorry, Your Honor, I didn't hear the first part of your question.
What about the extensive proof that came in at the trial regarding these uncharged crimes?
Okay, so there are really two categories of evidence that we're talking about here. One is evidence relating to the investigation of the Mercedes family narcotics trafficking ring. And the other is about the other category of evidence is drug paraphernalia that was recovered in the apartment. And I draw that distinction because there are two different analyses that apply here. The first category of evidence, the evidence of the organized drug trafficking ring, that's not Molyneux evidence at all, because the defendant was not, in our case in chief, was never implicated in that. And to be sure, on summation, we did argue eventually that he was involved in that, but that was only after Ms. Verdera opened the door to that when she testified, or volunteered really, that she, on cross-examination, that she never got him involved, when clearly she did. And so we were able to impeach her, and it was fair game at that point for us to argue that he was involved in summation.
Counsel, this is Judge Owen. I'm sorry to interrupt you. Going back to the weapons charge for a second, are you suggesting then that we have a reopening of the suppression hearing where the people sought to have the detective now testify because the DA agent is no longer available? Are you suggesting by making the arguments about that you didn't need those statements because you had overwhelming proof, or you had other proof to show constructive possession?
So, Your Honor, we think that even without the statement, that there would be sufficient proof to establish knowing possession of the gun. But certainly it's our argument that the statement adds to that proof. But yes, I think even if you were to take the statement out, I think there is still legally sufficient and also compelling proof of knowing possession of the gun.
Can we talk about the reopening of the suppression hearing? In general, once the court makes a ruling, the suppression hearing shouldn't be reopened absent a very high standard. Is that correct?
So, yes, Your Honor. I think
just on the law. Just on the law, right? It's not. If the court hadn't made a ruling, it would be a whole different thing, right? But the court already ruled. In fact, some years had gone by, right?
That's correct. There had been a prior.
Right, and the witness that you produced at the suppression hearing was not available, essentially.
That's correct.
So you were looking to get in a similar, but not the same statement, correct?
Yes, it was similar. It's not.
It's not the same. It wasn't that these two officers overheard the same statement made by the defendant, correct?
That's correct. They were separate.
Right. So why does that meet the high threshold that's necessary to reopen a suppression hearing? Didn't you know about the second statement during the original suppression hearing?
Yes, there's no question that we did. But Your Honor, I think the law is pretty clear that not every time the one opportunity rule, which is what the defendant is invoking in this case, it does not apply every single time that a suppression hearing is reopened. You need to look at the two policies or principles that really underlie that rule. The first is finality, which is basically not taking a victory away from the defendant. And the second is the possibility for...
Well, there's more to finality than that, actually. I mean, that the defendant would know in terms of preparing their case with some confidence what the proof is going to be. You know, if they're expecting a statement from police officer A at X time, then they go forward for years and they on the assumption that they're not going to get a statement from police officer B that was made at a different time. Isn't that a kind of finality?
Well, Your Honor, let me give two responses, or two parts to my response. The first is that when the case law has discussed finality, they've always discussed it in terms of preserving a defendant's victory. And that's been the narrow defining of the term. But to address your specific question, I think as the trial court pointed out, there was no surprise or unfair prejudice to the defendant in this case, because it's not like this statement came out of the blue 2 years later. It had been noticed in our VDF. He was aware of it. And, you know, it is substantially the same statement that Special Agent Eckert had overheard. Yes, they were made at different times, but the substance of the statement is essentially the same, and the defendant had notice of it. So there's really no unfair surprise or prejudice to him.
Okay, I'm going to ask you to wrap up your answer because your time is up.
Oh, okay, Your Honor.
Yeah. We have a tight calendar today.
If there are no further questions, we'll just ask that the judgment be affirmed.
Thank you. All right, rebuttal.
I want to go back to two misconceptions about the record. The first is that this drug paraphernalia was specifically brought in front of the grand jury, and Mr. Nunez was not indicted on it. So for the prosecution to bring up possession of drug paraphernalia throughout his trial, when a grand jury had already chosen to not indict Mr. Nunez on that allegation, was a violation of his right to fair trial. Now, with regard to the comment that Mr. Nunez's defense somehow opened the door to the analysis of the Mercedes family's drug trafficking enterprises, that's really untrue. And if I point you back to the record of opening statements by the prosecutor himself, he started this case out describing this as, quote, a lengthy narcotics operation into heroin trafficking in and around New York. He said that Ms. Ferdera was part of this narcotics trafficking conspiracy involving members of her family at literally every generation. These are quotes. That she was observed driving a Chevy Suburban from New Jersey to the Bronx. That the investigation continued for days, that it was a manhunt. None of this, he continues on, and it's in my brief, none of this is relevant to Mr. Nunez's allegation against him that he's being charged with knowingly possessing a gun. And with regards to the knowing element, I'm just going to remind your honors that all there is a gun hidden and locked inside of a closet. It was not in plain view. There was no DNA connecting Mr. Nunez to that gun. There were no fingerprints connecting Mr. Nunez to that gun. There were no witnesses that testified that they'd ever seen him with that gun. The presumption, while there may be a legal presumption, it's rebuttable, and in this case, it was extraordinarily weak. And for him to have been convicted on that presumption when there was a rebutted defense that contested his knowledge of that gun being in the apartment and nothing else supporting their claim, this drug evidence that came in certainly impacted the jury's ability to actually decide on the case that was before them, this gun allegation. And therefore, I submit.
Counsel, then are you arguing then, is it your argument, or you seem to be suggesting that it was more these uncharged crimes that convicted your client and not the reopening of the suppression hearing where the statement came in?
Your Honor, I believe these uncharged crimes, the reason for Mr. Nunez's conviction, yes. It violated, all of that evidence violated his self-standing right to a fair trial. And he was only charged with gun possession charges. None of that evidence should have come in, didn't qualify for background information, and therefore he is entitled to a new trial. Are there any further questions that I can answer for the court? Thank you very much.
Thank you. Thank you both. All right. Lynn against 100 Wall Street.
Yes, good afternoon, Your Honors. May it please the court. My name is Michael Altman, and I'm appellate counsel for plaintiff appellate Mr. Lynn. We submit that the evidence that Mr. Lynn fell from an unsecured ladder that moved demonstrated his entitlement to summary judgment on his labor law section 240 sub 1 claims. Now, in opposition, defendants made every conceivable argument. None of them should have been meritorious. Nonetheless, the motion court relied upon 3 of them in denying Mr. Lynn's motion for summary judgment. We submit the court erred in doing so. I want to discuss each of the 3 briefly. The first finding she made at page 9 was that Mr. Lynn gave contradictory evidence. And what she found to be the contradictory evidence was that his supervisor said that Mr. Lynn claimed that he slipped and lost his balance. As we demonstrate in our briefs, and we submit now, this court's decision in Marino at 159 AD 3rd 471 should be dispositive of that issue, since Mr. Lynn slipped and lost his balance after the latter moved. The second issue that the court found was that there was conflicting expert opinion that warranted denial of the motion. Now, the court listed those aspects of the opinion that she found to be conflicting. Those went to tertiary issues. They had nothing to do with the question of whether Mr. Lynn was entitled to summary judgment because he fell from a ladder that moved. To the extent that defendant's expert's opinion could be found to be read as opining that an unsecured ladder was sufficient, we submit that the copious precedent from this court holding that a fall from an unsecured ladder that moved demonstrates a violation of the statute controls, and the defendant's...
This is Justice Moulton. Wasn't the plaintiff described the ladder as very sturdy at certain points? And then also, Mr. King, his supervisor, said, I told him to use an 8-foot ladder. He used a 6-foot ladder. I told him 20 minutes before the fall. Why aren't those issues a fact?
As to the ladder seeming sturdy, ladders, I can't say always, but in most of this court's decisions where a plaintiff gets summary judgment, or many of them, the ladder seems sturdy until it wasn't. The fact that it seems sturdy until the ladder began to move and he fell from it and the ladder fell doesn't preclude the grant of summary judgment. And again, there are numerous cases where that's the case. Your question about the different heights of the ladder, and that goes to the third finding by the court, which was the recalcitrant worker finding. I think really what should be dispositive of the issue is that defendant's expert expressly opined that the 6-foot ladder was sufficient for the task Mr. Lim was performing. He made, the quote is at 975 of the record.
Counsel, why does that overcome what his supervisor told him to do? I mean, that's nice that the expert said that, but the supervisor was on the job and said, you should have used an 8-foot ladder. Why doesn't that create an issue of tribal fact?
Sure, because this court's precedent establishes that even if a worker didn't follow instructions, if that was not a proximate cause of the incident, or really the sole proximate cause, it doesn't matter. Because here Mr. Lin could reach the area where he needed to work on a 6-foot ladder, it's essentially irrelevant. That the proximate cause of his fall is that he was working on an unsecured ladder, had to have both of his hands over his head when he performed his work. The ladder moved and he fell. Now, what's very interesting is that the court, the motion court, did its own analysis. And she got everything right until the very end when it came to it, because she said that Mr. Lin could comfortably work from the 6-foot ladder up to 10 feet and 7 inches above his head. Now, he was working below that level. He was working on a beam that was 9.5 to 10 feet above. What I believe confused the court is that Mr. Lin was working on a drop ceiling, and there was a structural ceiling that was 11 or 12 feet high. And we absolutely agree that if he had been working at a height such that the ladder would have made a difference, then there would potentially be a recalcitrant worker defense here. We accept as true that the supervisor told him to use an 8-foot ladder, but it made no difference here because he was working at a height of from 9 to 10 feet. The size of the ladder had nothing to do with it. Plaintiff's expert found that, defendant's expert found that, and the motion court own calculations support that once the correct height is considered. I hope that answered your questions, Your Honor. If there are no further questions, I'm done for now.
Thank you. Respondent?
Yes, thank you, Your Honor. May it please the court, Rachel Camilleri on behalf of respondents 100, Wall, and Gant, USA. As detailed in our respondent's brief, the motion court properly denied plaintiff appellant's motion as the record is replete with material triable issues of fact such that any finding by this court would go against the long-held precedent that the credibility as well as the issues of fact need to be determined by the jury. Not only are there competing expert opinions of Ms. Hopkins and Mr. Farron, such that an award of summary judgment would be inappropriate, but there remain several issues of fact as to whether.
This is Justice Moulton again. Speaking of Mr. Farron, can you respond to what plaintiff said about Mr. Farron saying that a 6-foot ladder was adequate?
That is not my reading of the opinion by Mr. Farron. He surmised simply that if the height was 9 feet, he made no conclusion as to the height, and that was because Mr. Branham gave testimony that the height of the ceiling in the area where the accident occurred was 11 to 12 feet, thus laying one additional material issue of fact that has to be determined.
What about the distinction that was the structural ceiling that was 11 to 12 feet high? I mean, can't we find that as a matter of fact?
I don't think
and that the plaintiff was working on a drop ceiling that was lower.
I think that there's still the question of fact. There's testimony, yes, that it's the drop ceiling, but the testimony of Mr. Branham runs contrary to that the height at that location was 11 to 12 feet. And that's just one of several issues here. Additionally, plaintiff's own actions, he testifies that he didn't testify, but he immediately gave a statement to Mr. King that he lost his balance and then fell. He also
said that's not quite the whole statement. He said, I was trying to reach for something and lost my balance, which is really consistent, I think, with what he said at his ZBT. I really don't see the inconsistency there. And also, we're talking about this is a translation issue. The plaintiff spoke Chinese. That's what he said to Mr. King, who also spoke Chinese. But then in his EBT, he gave a slightly longer statement that really I read more as an elaboration of what he said to Mr. King.
And I believe there was elaborations throughout the testimony as well given. We cited the record, records 819 through 828. Mr. Lin, throughout his deposition, seemed confused, would elaborate throughout the deposition testimony. Those 9 pages, he continues to add on, and it's not until he's prompted that the testimony is given. And that we finally have a set of some facts that has been relied upon now by plaintiff and appellants in their papers. However, we do have statements that were previously made to Mr. King that were inconsistent. We then have Mr. King riding with Mr. Lin in the ambulance, and he's told that he's on the 4th step, then it's on the 5th step, several different versions. And this leads to the credibility of the plaintiff, and that is a determination that must be reserved for the jury and cannot be determined by the judge. And that's one of the reasons that the motion court denied summary judgment at this issue. In light of this, we find that there are several issues as to whether or not plaintiff appellant's own actions were the sole proximate cause of this accident, and that the jury needs to be the ones determining these issues. Moreover, the plaintiff appellant was the only witness to this incident. I noted that plaintiff appellant in his reply papers tries to make Mr. King a witness to the accident, although he is approximately 25 feet away. He gives
that's not your strongest argument. We've held many times it doesn't matter if it's only the plaintiff who knows the facts of the accident because there were no other witnesses. So that wouldn't preclude summary judgment.
That wouldn't preclude it, but here the credibility issue that we've previously discussed and is outlined further in our brief does prevent.
Well, that's a different issue.
That is a different issue, but it kind of runs parallel and intertwined. And then, so
additionally,
what's that? I'm sorry.
I said intertwined is the word of the day in arguments today. Go ahead.
Just had to hit on it, Your Honor.
Right. Go ahead. I took your time. Go ahead. You have another minute.
Okay. And Similarly, we do have very conflicting expert opinions, which again give rise that the motion court has properly denied the summary judgment motion here. Ms. Hopkins opined simply conclusory statements without any regard for what was within the record. And Mr. Farron, having reviewed the record, opined separately that the A-frame ladder with plastic feet was secure and that there was no violation here of Labor Law 241, and that there is no finding or any allegations that such violations may have contributed to plaintiff appellant's fault. In addition, I would just call the court's attention to the Morera case, which was previously decided by this court this year. Similarly, there, defendant respondents demonstrated that plaintiff appellant was provided an adequate protection such that a grant of summary judgment under Labor Law 241 was denied and upheld. However, here the plaintiff and appellant requests that this honorable court shift from the clearly established precedent and find defendant respondent liable solely under one set of facts that Mr. Lynn has provided, suggesting that the ladder was unsecured.
Thank you.
Submit that the decision in order of the motion court should stand. Thank you, Your Honor.
Thank you.
Good evening. Hello again, Your Honors. I'm going to try to be very quick here with respect to the Morera case, and Justice Gish, you sat on that. In that case, and I quote, "The ladder was being held steady at the bottom by a co-worker." If the ladder here had been held by anyone else or secured in any way, we wouldn't be here. There wouldn't be an issue. It's the fact that Mr. Lynn fell from an unsecured ladder that moved that established his entitlement to summary judgment. With respect to defendant's expert's opinion that an unsecured ladder was sufficient, I just note again that defendant's expert's opinion doesn't change this court's clear and settled precedent. To the contention that Mr. Lynn was prompted at his deposition and expanded on his answers, what my learned colleague refers to as prompting was questioning from defense counsel that elicited more information. There is no indication in the record that he was prompted in any way by his own counsel. And just the last point is, in our reply brief, we did not in any way, shape, or form contend or even imply that Mr. King was a witness to the accident. What we said is he was a witness to the immediate aftermath and was able to confirm the fall and the ladder on the ground. If the court has no further questions, we rest on the argument in our briefs.
Thank you.
Thank you, Your Honor.
Thank you both.
Thank you, Your Honor.
KS Trade. Okay.
Good afternoon, Your Honor. This is Michael Munoz for defendants, appellants, International Gemological Institute, Jerry Ehrenwald, and David Weinstein. If I may begin, the allegations in this complaint describe a narrow commercial grievance from which the plaintiff, based on wholly unsupported, conclusory, and speculative allegations, seeks to spin a tale of global conspiracy, antitrust violations, violations of the general business law, and a host of other causes of action against individuals and entities. The court below granted our motion to dismiss several of the claims and denied our motion with respect to others. I'm aware my time is somewhat limited, so I'll try to hit some of the highlights. Certainly, if anyone has any questions, I'm happy to address those. I think on the GBL claim for deceptive conduct, the lower court found that the defendants engaged in deceptive conduct by demanding an illicit fee from the plaintiff in order to give jewelry that he submitted for certification the grades that he wanted. The plaintiff, completely with no support, separately alleged that the public was harmed because, in his telling, which is speculative, other
Well, it's allegations. I mean, we're still on the pleading, so,
Yeah, the pleading
you know,
motion.
whether it's speculative or not, you know, I don't think it fits into the calculus. You know, but as I understood the lower court decision, and you could address if this is right or not, that the public was implicated because ultimately the scheme that was alleged resulted in the public paying more money for diamond and diamond jewelry than it was actually worth.
So even if we are to credit that allegation, which again, there's no just guesswork in the complaint.
I understand you have defenses to this and factual defenses.
So,
but
so
let's accept it as true because that's the legal standard.
In that case, Your Honor, the lower court found that the deceptive conduct was the charging of this illicit fee, that was the injury to the plaintiff. The injury to the public, as alleged, is entirely different, and it is attenuated. It is.
Well, the injury to the plaintiff was more than just the fee. It was that they were squeezed out of the market to offer diamonds at appropriate value.
Your Honor,
you may have the same argument with respect to that, you know, that it's a different injury than is ultimately alleged to the public. But it wasn't just that they had to pay the fee. It was that they didn't pay the fee and they were squeezed out of the market.
And that is an injury specific to the plaintiff. And in this case, bearing in mind the Court of Appeals admonition that the GBL is not to be used to litigate private commercial grievances, we point out a number of cases in our papers where a GBL claim is dismissed, even though in the course of the alleged conduct, there is some negative effect on the public down the road. That is not sufficient for this plaintiff to state a GBL claim the way that it did.
Okay, your time is up, Counselor.
Okay, thank you very much, Your Honor.
Yeah, well, you'll rely on your briefs. They're pretty complex. Thank you.
Yeah, thank you.
All right, the counsel, well, it's not co-counsel, counsel for the other defendant.
Certainly, Your Honor. Good afternoon. May it please the court. I'm Michael Bedell and Foreman, representing defendant appellant Brody Copeland, Inc. We brought this appeal, Your Honor, seeking reversal of the lower court order denying the dismissal of plaintiff respondent's allegation that Brody Copeland aided and abetted an alleged fraud. Plaintiff respondent was obligated, but failed to plead its aiding and abetting claim in detail from the outset. They were required to explain how the alleged acts of Brody Copeland substantially assisted defendant's fraud, and they failed to do so. Instead, plaintiff respondent proffered only conclusory allegations that offered no details as to how my client could have possibly aided and abetted.
False invoices, counsel, are mentioned in the complaint. Why isn't that sufficient? I mean, in other words, here's a place to park your money. We'll paper it up. Done. Why isn't that aiding and abetting?
Yes, Your Honor. Even assuming that's true, as we must at this stage, it wouldn't have hidden, and this was their allegation, it wouldn't have hidden any alleged illicit payments to IGI in exchange for regrading diamonds. Those payments would still be on IGI's books and records. They still would have been available to auditors. Nothing we were alleged to have done would have hidden or laundered anything. If anything, if we did what they said, we would have added questionable entries onto the IGI books. Again, nothing we did. We had no access, and there's no allegation we had access to IGI's books and records. There was no possible way we could have hidden any money that went to IGI, and there's no allegation we accepted any money from any jewelry manufacturers.
Well, I thought the allegation was that you rendered invoices for services that were never given. So you collected in cash that they had to launder, that they had to get rid of, they had to make legitimate. So they put it into what appeared on its face to be a legitimate business transaction, paying you for services, when in fact you didn't provide any services.
Even if that's true, Your Honor, that is the allegation, but even if that's true, that would not have served to hide anything. Everything was on the books. So even if we submitted invoices for work not performed and collected payment for that work, any illicit payments that went to IGI, any funds that went to IGI, they're still on IGI's books. It wouldn't have hidden anything. It wouldn't have laundered anything. That is the allegation. That's correct, Your Honor.
That could be an argument on summary judgment, counsel, but we're on it's a pleading motion.
Correct, Your Honor. But even on the pleading motion, when you're alleging aiding and abetting fraud, they have to allege from the outset with particularity how we aided and abetted, how we substantially assisted the alleged fraud. So you're right, Your Honor, it is beyond the bare pleadings at this stage for such an allegation. They also allege, just to go to their allegations, they also allege that the payment to Brody Copeland was really a means of compensating David Weinstein. Brody Copeland is owned by Karen Weinstein. David Weinstein works for IGI. Karen Weinstein owns Brody Copeland. So there is an allegation that the payment to Brody Copeland represented a way to compensate David Weinstein. This allegation also fails because an element of substantial assistance is proximate cause. And there's no way and there's no explanation as to how anything we did could have proximately caused any injury to the plaintiff. Again, even assuming all the allegations are true, they can't credibly claim that but for Brody Copeland, this scheme would not have gone forward. I mean, on the one hand, they're arguing that this is a sophisticated international scheme to regrade diamonds in exchange for illicit payments. On the other hand, they're saying that if one of the participants' wife's companies wouldn't accept money, the whole thing would have fallen apart. If David Weinstein weren't married, or if his wife...
I don't think assistance means the whole thing has to fall apart, but we understand your argument. Thank you.
Thank you very much, Your Honors.
Thank you, Your Honors.
Okay, the next case is Ramos against Metro North.
Good afternoon, and may it please the court. My name is Damian Cavallari from the law firm Hoge, Newman, Regal & Kenny, representing defendant appellant Metro North Commuter Railroad and the individual defendants, respondents, Joe Strini, Justin Vonashek, and Gary Martens. This case is about a former Metro North employee, plaintiff Andrea Ramos, who was terminated from the position of accident investigator, a 24/7 safety-sensitive role, after failing to notify her supervisors and Metro North that she had been prescribed certain medication and failing to take herself out of service when she had taken such drugs due to their potential adverse effects. This violated Metro North's alcohol and substance abuse policy and operating rule G, which together comprise Metro North's policy concerning the reporting of prescription medication. This appeal requests that the court reverse the trial court's April 3rd, 2020 decision insofar as it denied Metro North's motion for summary judgment and dismiss plaintiff's remaining claims. Such relief is appropriate for several reasons. First, Ms. Ramos's employment was terminated for a legitimate, non-discriminatory, non-retaliatory reason. She violated Metro North's prescription reporting obligations and failed to notify her supervisor that she would not be available due to taking such medication. This violation is not in dispute. Second, there is no evidence that plaintiff was treated less well than any of the other accident investigators in violation of the New York City human rights law. Third, the trial court erred in relying
Just to stop you on that one, counsel, I mean, she has a lot of allegations in her affidavit about how she was treated less well than their two equivalent white male colleagues. Why does that create an issue of fact about disparate treatment?
Respectfully, Your Honor, she doesn't actually state that she was treated less well than they. She describes allegations that she wasn't treated better than others, but there is no actual comparator to a similar situation that she had. None of the other accident investigators received any benefit that she did not. When it comes to the work hours, her work hours were in line with what the other accident investigators were. When it comes to training, she was granted the same training opportunities as the other accident investigators. She was able to select what work locations she worked out of, and there really are no specific instances in which she was treated less well than the others. There are certainly claims that she wanted to have additional benefits and not have to do the same things as the other accident investigators, but none of that actually demonstrates that she was treated
Wasn't one of her peers not upbraided for not using the company car, whereas she was frequently upbraided for not using the company car?
That is
an allegation.
Respectfully, Your Honor, that's incorrect. She was told to use the car daily for commuting purposes, like the other two accident investigators, and those two did exactly that. The record reflects that that's exactly what they did using GPS reporting. So in the event here, she was asking not to use the company vehicle, which was something that the other two accident investigators were required to do, and in fact did.
Well, also, counsel, just going to the disability claim, I know I'm switching gears a little bit, but they didn't have disabilities, allegedly, or there's no allegation that there were. She did. Was there any attempt to reach a reasonable accommodation by?
Absolutely. Absolutely, 100%, Your Honor. She engaged with Gary Martens over the course of 3 months, during which he advised and worked with her to try to find a reasonable accommodation. That she didn't get the requested accommodation is irrelevant. What we're looking for is, was there a reasonable accommodation available to Ms. Ramos? And here, that process actually had not completed. Whether, yes, there was a letter that was in the process of being drafted that would have denied her requested accommodation. The process was an ongoing process. The fact that she violated vital Metro North policy and was terminated as a result of that violation was the only reason why the interactive process was interrupted. But as I said, this process was ongoing, and you'll see in the record that there is a chart of all the interactions that Mr. Martens had with Ms. Ramos in order to try to find whatever that reasonable accommodation may be. The trial court erred in one fashion insofar as Judge Heitler believed that there had to be an in-person interaction, but that's not necessary under the law. There were several telephone conversations and even emails that went back and forth between the two, demonstrating that the interactive process was something that was ongoing. Another error from below was the fact that the trial court relied on two unsupported and conclusory assertions by plaintiff's two experts. These experts made claims and statements trying in order to take the place of the fact finder by asserting that there was some sort of discrimination based on facts that were demonstratively incorrect in the record. One of those facts being why Ms. Ramos was the individual that was selected to respond to the derailment at the New Haven yard in the early morning hours of March 16th. Mr. Strzok stated in his expert report that he believed that Ms. Ramos was further away when in fact that was demonstrably untrue. And at this point, that was one of the main reasons why there's a belief that Ms. Ramos was somehow selected in some sort of retaliatory way. Also, notwithstanding the fact that Mr. Ferlato, the other accident investigator, had just finished a 24-hour shift in trying to respond to Winter Storm Stella issues. Finally, with respect to plaintiff's cross appeal, plaintiff waived her claims against the individual defendants by not opposing such part of defendant's motion below. And in any case, none of the individual defendants are owners or officers, nor are they individuals with independent authority that would permit individual liability pursuant to New York City human rights law. If there are no further questions, I will be back on rebuttal. Thank you, Your Honor.
Mr. Fuchsberg?
May it please the court, I would first like to correct 2 points. Footnote on page 28 describes in detail, looking at the GPS records, how Mr. Ferlato, a peer white male employee, frequently left his car at home, and he was not sanctioned for it. Secondly, there was a discussion on how the interactive process continued, but in fact, her PIP was amended, her performance improvement plan was amended and extended, although she had not violated any of the provisions in the performance improvement plan. Of note, that amendment occurred after she had completed her reasonable accommodation request. And
Counsel, let me interrupt you for a second. Can we pick up the thread on the individual defendants? Did you waive that below?
No, I'm sorry, we didn't waive it below. We didn't artfully argue it by putting it as a separate point in our brief. But we put in all the details and all the facts, and the court addressed it on the merits. And we never indicated at any point that we were waiving it. We indicated, in fact, that we were, opposing the motion in all regard. And the Court of Appeals has addressed this issue before, and the art of how you argue it is not necessarily the way that the court should rule. In this case, it was looked at by Judge Heitler below, and she did rule on it in substance. So it was not waived, although I agree it could have been more artfully argued as a point in the brief. But the point about the PIP being extended after she was on a reasonable accommodation is that she could not at that point look for another job in the railroad. And if you look at the notes of Mr. Martins, who was with Human Resources, one of the things that she indicated is that then let me look for another position at this large railroad where she had been a manager and worked in another department, the operations department, and she'd worked there successfully for 10 years. And the vice president of Human Resources says in the record at page 3317, when she was asked whether it was feasible to find a reasonable accommodation by placing her indeed in another department, she said, I couldn't do that because the performance improvement plan was in place. And when the performance improvement plan is in place, an employee is not allowed to look for a position elsewhere in the railroad, may not apply for a position. And she said she didn't know of any way around that. I would like to discuss the discriminatory motive for termination and the contextual mixed motive, as well as our claim that there was retaliation in regard to her EEOC filing. Her termination raises both a question fact of mixed discriminatory motive as well as retaliation. The termination pretextually arises from her refusal to accept an assignment at 2 a.m. because she was on prescribed medication for her back, which medication she previously reported as part of her FMLA medication. Thus, Judge Heitler ruled it was a question of fact, since that application was reviewed by the very same Office of Occupational Health and Safety, the very same office where she would need to tell them of prescribed medication, and that FMLA application indicated that she was on prescribed medication for her back. At no other instance in the 2 years had she been called into service at night. Under railroad rules, the medication does not allow her to go into service, and therefore she correctly acted to decline service and advise her that she had taken that prescription. There is no rule that she has to report in and take herself out of service every time she takes a prescribed medication. The 24/7 policy is not in writing, and as described and as discussed by our expert, is not a proper standard policy, because there is not, like some people are on some days 24/7 and others are on other days 24/7. How could we all be on all the time 24/7? And for this, she was summarily terminated when the policy says up to and including termination, does not require termination. And she's an 11+ year managerial employee with technical skill and knowledge in how conductors must conduct themselves, which is a material technical skill that she has. It's very important in accidents investigation. And she got that job on merit. And she was taken out of service by Defendant Strini and fired by Defendant Bonashek, the persons behind her denial of a reasonable accommodation.
Your time is up, Mr. Fuchsberg. Why don't you wrap up your argument, please?
While that Andrea Ramos maintains a case of disability discrimination under the city human rights law, and that she suffered from a statutorily defined disability, one that permitted her FMLA approval, and that was found by Metro-North's medical review officer to meet the criteria for a request for reasonable accommodation. This very disability caused the behavior for which Ms. Ramos was first punished and then terminated. There is enough material evidence here of all of these issues under the New York City human rights.
And you're asking us to uphold Judge Heitler's decision.
Very well reasoned decision.
Thank you. All right. Rebuttal.
Thank you, Your Honor. To begin, the 24/7 responsibilities are in the job description at record page 289. So in going to the egregiousness of Ms. Ramos's violation, she has an obligation to inform her supervisor when she is going to be out of service or when she may potentially be unable to respond. And she just did not do that here. She knew what the rules were. She instructed on these rules and she failed to comply with them.
Are the rules in writing?
Absolutely. They're on, if you go, if I could direct the court to pages 300, I believe, and sorry, Your Honor, yes, 300 and 324 of the record, you'll see the two rules, one under the alcohol and substance abuse policy and Rule G, which is on page 324. And to note, Rule G is a customary rule for railroads. And as the Supreme Court noted in the Skinner case, which is cited in the briefing, the customary sanction for a violation of Rule G is termination.
But are those the 24/7 rule?
The 24/7 is part of the job.
policy.
The 24/7 is part of her job description. And Rule G requires
Every
that
day, 24/7?
right, she is required to be available 24/7 on an emergency basis. This does not come up that often, but the question is, if she's going to be unavailable, she needs to report that a period of time, whatever period of time that is, when she is unavailable. In this case, it would be when she takes an orally administered prescription medication that can have adverse effects. And what Mr. Fuchsberg is referring to with respect to the FMLA application was a single instance where the doctor checked a box saying that she was prescribed medication for the condition that she had. That medication is not necessarily orally administered medication that would have also required her to go to the medical review officer to seek approval or authorization or maybe even instruction with respect to how to use that medication while she's in service. In this instance, she could have simply said, my back is acting up, I'm taking a medication, emailed her supervisor, and that would have been that, and they would have found alternate coverage for that evening or for that early morning. But she simply did not do that.
All right, thank you.
Thank you, Your Honors.
Thank you both.
Okay. Thank you, Your Honor.
People versus Kareem. Oh, forgive me, I made a mistake. I took a case out of order.
So.
All right, the next case is Sung versus So. We'll do People versus Kareem after.
Good afternoon, Your Honors. Catherine Chestnut for the appellant, and may it please the court. Appellant has two pending appeals before this court, and I will be arguing the custody modification appeal, and my partner, Jason Advocate, will be arguing the counsel fee appeal. The primary issue in this custody appeal is that there was no basis for the court to grant the respondent's motion to modify the party's so ordered custody agreement. Respondent filed his motion to modify custody only 2 years after the parties had settled custody in their divorce action. The standard for the court to apply in modifying a custody agreement is that there must be a substantial change in circumstances since the agreement was entered into, and that as a result of that change, it would be in the best interest of the children to modify custody.
Counsel,
the focus
what's their
should
change of circumstances when a spouse gets a job and previously they were a stay-at-home parent. That's a change of circumstance. And then there are also allegations about the mother's lack of cooperation with the father and some behaviors with respect to the children. I mean, not taking those at face value, but isn't that sufficient to create a change of circumstances warranting a hearing?
Your Honor, I don't believe that meets the standard in this case. The mother's return to work was anticipated at the time that the party settled custody, and that on its own, I don't believe would be a sufficient change in circumstances, particularly since after the party settled custody, the mother continued to be the primary parent here, and due to the father's need to travel for work regularly, she actually agreed to swap 120 overnights during those first 2 years that they were following that custody agreement. So there, I think the mother remained the primary parent, and that wasn't a basis to modify the party's custody agreement. With respect to the father's allegations against the mother, we believe that all of those allegations were very minor complaints. They were petty. They were the claims of interferences. There were 3 interferences in the father's underlying motion. One of those interferences was when the mother asked that the father put guards on his balcony door after she witnessed their 5-year-old son balcony door unattended while the father was in another room. The other incident was where the father wanted to take the children out of school early to start his spring break vacation with the children. The mother agreed for him to do that in exchange for him returning the children to her one night early at the end of the break because he was taking her time. The third incident related to a legitimate dispute between the parties over whose parenting time it was because of a swap in their parenting time resulting from the father traveling for work. There was only one occasion at all in which the father says that the mother actually did not return the children, and that was over a legitimate dispute about whether it was her weekend or his weekend. The Court of Appeals has explained in Obey v. Degling that custody of children should be established on a long-term basis whenever possible. And in Eschbach v. Eschbach, the court said that where the parties have entered into an agreement as to which parent should have custody, that priority, as an absolute, but as a weighty factor, should, in the absence of extraordinary circumstances, be accorded to that agreement. Here, there are no extraordinary circumstances. There wasn't a basis for the court to hold a hearing to modify custody, and the court should have dismissed the father's petition, the father's motion, as soon as based on the papers alone. The burden was on the father to establish a change of circumstances, and he failed. Notably, everyone in this case agreed that the children were thriving under the parties' custody agreement, under which the appellant was the children's primary custodial parent, including both parties, the attorney for the children, and the forensic evaluator. Everybody in this case testified at the hearing that the children were thriving. When the children are thriving under agreement, there's no basis to modify it.
Counsel, this is Judge Owen. I have a question. The whole thing about whether or not there was a substantial change, that's at the discretion of the judge, isn't it? To decide if that actually has happened before a hearing is held. And that's what Justice Cooper found, correct? Or unless I'm looking at the wrong record.
Well, the determination of whether there was a substantial change, I don't know that Justice Cooper determined that there was a substantial change before he held the hearing. I think perhaps in holding the hearing, it's implied that he made that finding.
Yeah, I mean, he has this case from the beginning, correct? From inception.
Yes.
So he knows everybody. He knows what's going on, so that you can, without him dotting and actually saying it, it's clear that if he held a hearing, there must have been something for, Justice Cooper just doesn't do anything for the sake of doing it. He does it something because something is there for him to do it. So he held the hearing. So unless you're saying that there was an abuse of discretion on his part, that he totally missed the boat, and then he held the hearing, and then he made his findings after the hearing.
Well, I'm not saying that he totally missed the boat, but I do think that
He's been on this boat for a long time, so he knows everybody.
I understand, Your Honor, but I think that he did err in holding that hearing, and I don't believe that at the end of the trial there was any evidence of a substantial change in circumstances. Comparing the facts of this case to the facts of other cases in which the courts have held there were substantial changes in circumstances, those facts just aren't here.
For counsel, we have to agree, unless you're going to disagree with me, every matrimonial case stands and falls on its own. There is you may have some similarities, but on the whole, they're really unique in its own right. That's just the way it is, right? Nothing fits perfectly into a square or a circle. There are nuances that the trial judge, especially Judge Cooper, he's going to be able to see or observe.
That's correct, but here
I got you to say that's correct. That's good. That's a good start.
But the fact is that the respondent can't point to a single example of a substantial change in circumstances.
Counsel, but that's where we disagree. You can say the respondent can't point, but Justice Cooper is a pretty good jurist, and without you pointing, he may be able to see something and figure it out, right? You're casting on the point that the respondent can't point to this, can't point to that. But Justice Cooper may have saw something amongst everything that was going on during the hearing that he didn't need anybody to point. He didn't need to have a guide or a roadmap, right? That's where we're going. That's where I'm coming from.
I want to reserve a minute of my time, at least for my partner. But but if I could just briefly respond to that, I think that the problem is that I don't see a substantial change in his decision. Yes, overall, he may have determined that collectively he saw some substantial change, but he would have had to articulate that change in order to have a justification for modifying the party's 2-year-old custody agreement. And now I'm going to turn the virtual podium.
He actually only has 38 seconds, but I'll give him 2 minutes, and I'll give Ms. Moss an extra 2 minutes as well.
Thank you, Your Honor.
Go ahead, Mr. Advocate.
He's muted. You're muted.
You're muted.
You just lost 10 seconds.
Sorry. May it please the court. Thank you, Your
Now
Honor.
you know not to let her go
It's
first.
only because of the vigorous questioning by my colleague that used up so much time, so I'm giving you time.
Don't let her go first next time.
May it please the court. Your Honor, the issue that I'm addressing is the legal fees and the attorney for the child's fees and the forensics fees. This is an issue that's less fraught and less complex, I think, than the custody issues. It's a little bit more straightforward. My client was contesting the husband's request to change custody. The husband was successful on a good portion of his custody petition. He was not successful on everything, but success is not the barometer of whether someone should get some contribution from the spouse. What the courts are looking at, and the statute is designed to address, is financial disparity. And in our situation, we have a case where my client works at JP Morgan. It's in the record. She's a low-level worker. She makes $55,000 a year. She has investments that she got from the divorce case. She made a couple $100,000 from that. Presumably, because we don't know, the husband has his own equitable distribution he got a few years ago, but he's making $800,000 in financing.
Counsel, I mean, Justice Cooper isn't Justice Cooper justified in drawing a negative inference against your clients based on what Justice Cooper called a perjurious net worth statement?
Judge, first of all, we took that net worth. It was erroneous. It wasn't really perjurious. Okay. And what we did was we withdrew that application. What we did was it truly was not, Judge. The issue on that one was that she felt that a house which was really bought by her parents, which her name was on, shouldn't be on there. He pointed it out. We withdrew the motion. It was then subsequently a new net worth thing was filed that was totally correct, and a new application for legal fees was filed. So the judge initially, declined. That was correct. What he did was 100% legally and factually correct by saying, I'm not going to award you any legal fees on that net worth statement. They filed a corrected one. The corrected one addressed all of his legitimate concerns. And at the end of the day, the other side never even submitted their own net worth statement. So there has to be a negative inference against him. The fact is, what I did know was he did produce one thing during the case, which was a 2017 W-2. It showed that he made about more than $800,000 in 2017. We don't know what he made in 2018, 2019, but the fact that he didn't submit a net worth statement, he's clearly making more. He probably has similar investments. He's probably making over $1 million a year. This is not a situation where my client's going to be destitute and is going to be in danger of becoming a public charge. But she's dipping into a sizable amount of her assets to defend against the husband's lawsuit. And he is going to be able to make those assets back in ways that she will never be able to make back. So that's why an award of counsel fees should have been done to some degree. And we weren't asking for 100%. We're asking for less than 75%, about 70% of the legal fees. And lastly, on the issue of the AFC fees.
You're way over the extra 2 minutes that I gave you. So last point, you're done.
Last point. The judge set a 65-35 ratio with my client, the less money parent, paying 65% of the AFC fees and 65% of the forensic fees. When he eventually, in the custody case, did a PC, a parenting coordinator, he assessed the numbers 85-15. There was no reason during this case my client should have been paying the AFC's fees 65% and no reason 65% of the forensic when she made 15% of the combined parental income by the judge's own estimation. So I'll end there. Thank you very much for your time, Judge, and all your judges. Thank you very much.
Thank you.
Good afternoon, Your Honors. My name is Sue Moss, and I represent the plaintiff respondent. To start off about the custody appeal, I'd like to point the question was that there was never any pointing as to what the change of circumstances are. So if I may, I'd like to lead this court to exactly what those changes were. The original underlying order was based upon a forensic exam, the results of a forensic exam by Dr. Alan Ravitz, who said that he was agreeing or he was recommending that the mom receive more than 50% of the time because she was more physically able and was not employed outside the home. Dr. Ravitz continued to state in his report, which is in evidence in this trial, that if the mother were to become employed full-time outside the home, then modification of the parenting plan should happen. And that's page 42 of that first report. So number one, that's our number one that I'd like to point to. The next change of circumstances is the mom's behavior with these children. The mom was shown in our initial papers to be substantially infantizing these children. That means she wasn't letting these children who, at the time that we complained about it, were 10 and 8, wouldn't let them eat their own food alone. She would insist upon feeding the children. Now, even worse than that, she'd insist upon feeding the children so substantially that the children would throw up and gag. Now, this was done on a FaceTime, so luckily we had proof of this behavior that Judge Cooper was able to see. When the children would go to the bathroom, she would insist on going to the bathroom with them and wiping them and not allowing them to wipe themselves. She would insist on the daughter, even when she was age 10, picking out the clothing for her. So she wasn't even allowed to pick out her own clothing. There were substantial other examples of the infantizing, but just to move forward to more points that I can make of how there was a change in circumstances. There was a parenting coordinator set to help with the access problems between the parties. At no time did the mom ever agree to what the parenting coordinator was suggesting. And in fact, it was the parent coordinator who said that my client should go in to change to do a new parenting schedule because the mom was insistent on limiting my client's access to the kids, even when she had no right to do so under that first parenting order. She wouldn't allow my client to have makeup time, and there were other substantial problems. Then ultimately Judge Cooper appointed an AFC. The AFC, the attorney for the children, who represented and spoke to both children, explained they were in no way incapacitated. These children talked about how they wanted to spend more time with their dad. They talked about how when they had a problem, they felt more comfortable talking to their dad because their mom was inflexible and that she was not listening to their point of view. They went on and on, both children, of examples of the reason why they wanted to spend some more time with dad, and that those reasons, not just I want to spend more time with dad, but reasons that when we're with mom puts down dad and says negative things about dad, but dad doesn't say negative things about mom. There was reason after reason after reason brought forth not only for the attorney for the children, but but also by ultimately the forensic who was reappointed to do a new examination. So it's absolutely not true that there wasn't reasons for change of circumstances. But once we had this trial, the attorney for the child and the forensic went example after example after example of why it was important for the father to have more time with the child. I do want to move on. The issue was, are these children thriving? They were not thriving. There was not evidence presented that these children were thriving. The mom was trying to infantize these children so that they would not grow up as they normally should. That in no way was thriving, and there was no such testimony in the course of the trial. I'd like to move on to counsel fees. with regard to counsel fees, as with regard to decisions concerning custody, absent, these issues are in the sound discretion of the court, and absent an abuse of discretion, the reality is the determinations by the underlying court should hold. With regard to counsel fees, counsel fees awards are determined by a number of different equities and circumstances that include whether either parent has engaged in conduct or taken positions resulting in the delay of proceedings or unnecessary litigation. Another issue is the relative merits of each party's position, and the third is the respective financial circumstances of the parties. In this particular case, the appellant's obstructive behavior and dilatory tactics were so substantial that in the court's decision, the judge goes on and on for pages of all of the different obstructionist behaviors and how the mom prolonged this litigation. With just touching on some of them, we had appearance after appearance, which cost both parties substantial counsel fees. In those appearances, mom each time said she agreed to a settlement. And then my office would go back and we would draft a lengthy agreement. Then she'd come back and say, no, I don't agree, but I'll agree to this. So my office would go back and spend even more money revising that substantial agreement. And we would go on and on and on. We wasted more court appearances where the mom would stand up through her counsel and say, I agree. And then she would fire her counsel. Then we would come back and her new counsel would say, I agree. And then she would fire that counsel. Mr. Advocate's office is, I believe, at least the fourth counsel that mom has had. And the reality is that she is responsible for the prolonged litigation. And the reality is that is demonstrated through pages and pages of the court's oral decision, where he goes through everything that mom did to cause excessive amounts of counsel fees and to provide excessive delay in this case, and that she shouldn't be rewarded for that. With regard to whether or not she is the non-moneyed spouse, as your honors of course know, there is a rebuttable presumption, and we think, and even if this court were to find that my client was the moneyed spouse, that presumption is rebutted, because no litigant should be able to be this obstructionist and think she's gonna have to pay zero of her counsel fees or get any of her counsel fees. But the mother in this case is admittedly a multimillionaire. Her net worth shows a gross income of $258,794 per year. So understand, this is not, and that is on page 140 of the record. So to say she only makes a small income is just not true. She also gets support from my client in addition to her income of $180,000 a year. That's in addition to the $258,000 and change that she earns. Now, she also has assets totaling in the millions of dollars. So, my client my client does make, approximately $700,000. But the reality is there is not as big of a discrepancy that would warrant counsel fees when she has been responsible for delaying this case and for really taking positions that were incredibly, well, certainly they were not accepted by the court, and they were positions that were erroneous, especially when you heard from the attorney for the children, and especially when you heard from the forensic who presented another substantial case. I believe my time is up, so I thank you for your patience.
Thank you. Okay, 2 minutes on rebuttal.
Your Honor, I'm going to take the rebuttal to address the legal fees issues. I think there's been quite a substantial amount of argument on the custody issues. With respect to the legal fees, Your Honor, my esteemed counsel, Ms. Moss, is just mistaken on several accounts. The obstreperous and obstructionist conduct that she describes is nothing more than my client wanting to proceed with a trial And I do believe that a mother who wants to adhere to an agreement that was entered into 2 years ago has a right to do so. She doesn't have to be forced to settle. There's a lot of discussion by Ms. Moss about settlement efforts. Those are Dehors the record. And at the end of the day, there was no settlement. But you cannot punish the mother here for refusing to settle the case and to change a custody agreement that was entered 2 years ago. My client had a good faith belief that what was in the best interest of the children was to keep the existing schedule, both the schedule and the joint decision making. She prevailed on the joint decision making and she did not prevail on the visitation, but she has an absolute right that should be supported to go to court. And if she has to go to court, and if the husband is making that sort of money that he is, which is not $700,000, it's over $800,000 in 2017. We had no idea what he was making in 2018 and 2019. We also don't know what his investment incomes was. He could be making millions of dollars. We have no idea. The reality is he is by far the moneyed spouse, and he should pay something on that. And there is no question that he should have paid at least 85% of the attorney for the child's fees and the forensic fees. There just is no reason why that shouldn't have happened. And to do otherwise is simply to punish my client for exercising her constitutional rights to contest custody and to actually want to adhere to an agreement that was entered into just 2 years ago. So thank you very much, Your Honors, for your time today. If any questions, otherwise I'm done.
Thank you. Thank you
Thank
both.
you. Thank you.
Thank you.
People versus Kareem.
Good afternoon, Your Honor. Abigail Everett for Appellant Kevin Kareem. The jury should have had a chance to deliberate on the lesser charge of attempted second-degree assault, which requires proof of attempted serious physical injury, but without use of a dangerous instrument. Dr. Painter testified that the complainant's injury was caused by a punch to the head and fall to the ground rather than the boot. And the prosecution's doctor did not contest that. That doctor testified only that significant force had been used. Moreover, this is a case where the jurors acquitted Mr. Kareem of second-degree assault, which also required use of a dangerous instrument. And there's really no question that physical injury, which is the other element of second-degree assault, occurred when there was a skull fracture. Now, it was defense counsel's mistake that prevented the jurors from considering the evidence that more appropriately suggested attempted second-degree assault rather than attempted first-degree assault.
Was that a mistake or a strategic decision by defense counsel to have assault in the third-degree charge instead of assault in the second degree?
Well, I think although there are cases where this court has looked for these issues to be litigated on 440, there are also cases where these ineffectiveness issues have been reached on direct appeal. And I would submit on this record, it's clear that this was not a strategic decision. One, he's already served the time for both of the lessers. But two, more importantly, once the court denied the justification charge, he really had no other viable defense in this case. Because as I said, it's clear that he wasn't contesting that he had punched the man, or he was contesting really the instrumentality of the injury. And for that reason, there was no really sustainable strategy for not asking for the parallel lesser on the first count that the counsel had asked for on the second count. Now, it's important to remember that the judge actually denied the request for assault in the third degree on the ground that the DA has argued in the respondent's brief that there was no right to that lesser, not because there wasn't a reasonable view of the evidence, but because it was a different instrumentality. And in our reply brief, I think we cited several cases, most significantly this court's case in Bassiano, where this court has recognized that if the defense puts on a reasonable view that the injury was caused by a different instrumentality, that doesn't prevent the judge from charging the lesser. So you can see that the reasons the judge gave for denying the assault 3 count were really invalid. Now, that's not an issue on this appeal because the jury acquitted Mr. Kareem of second-degree assault. But the reasoning would have held true also for the first count. And we asked the court not to accept the respondent's argument that that would be a basis for denying the lesser on the first count, excuse me. And I would briefly like to address the question of the justification charge. Remembering, of course, that you have to look at the record in the light most favorable to the defendant, counsel below marshaled several facts in the case that would have supported the justification charge. Now, we know that in the first trial, justification was given. This court reversed that. And Mr. Kareem did not testify at the second trial. So the question is, what was presented in the second trial that would still support this justification charge? You've got the fact that a defense witness testified that the complainant threw the first punch. You've got the barking pit bull dog and the fact that the complainant had warned Mr. Kareem that the dog wasn't a danger unless he...
But counsel, I mean, what about is there a contradiction that this is a dangerous instrument case? I mean, if it's a dangerous instrument case that's capable of providing, inflicting deadly force, I mean, doesn't that make it impossible to do the kind of justification defense that you're asking for?
Well, I think that was a theory that the Court of Appeals rejected in Vega when they held, and Vega is cited in our briefs, that the mere fact that the jury is deliberating on a count that has an element of use of a dangerous instrument does not preclude the court from giving the justification charge if the record as a whole presents, in the light most favorable to the defense, a view that there was a legitimate fear for his safety. Now, there was also testimony that the bus driver said the complainant was starting to get up. This is a fast-paced event. The defense witness said that the defendant was knocked into the bus, which was right on the curb. This is rush hour. There's a lot of traffic. There's a lot of pedestrians. And the other thing, of course, is the court's feeling that there was so much evidence of retreat opportunity that the charge was not warranted. But again, if you look at the fact that it's happening fast, there are a lot of pedestrians surrounding these people as the fight is going on, that Mr. Kareem may not have understood immediately that he could have retreated under the fast-paced efforts, and for that reason it was error to hold that there was so much evidence of duty to retreat that the charge would not be appropriate. For those reasons, we ask the court to reverse the conviction and grant Mr. Kareem a new trial.
Thank you. Okay, people.
Good afternoon, and may it please the court. I'm Jennifer Westfall for the people. Defendant received a fair trial and the people's evidence supported his conviction. We're also arguing that it was possibly a strategic decision that defense counsel failed to request a submission of the lesser included offense because he could have possibly been willing to accept the misdemeanor conviction for third-degree assault, but not another felony conviction for attempted second-degree assault, which could have serious sentencing consequences in the future. Additionally, beyond that, defense counsel was not ineffective for failing to request a submission of the lesser included offense because it simply wasn't warranted in this case. Defendant was not charged with a punch that caused the victim to fall. Because the fist fight was separate from the later stomp, this conduct could not form the basis for the lesser included. Finally, the trial court appropriately denied defendant's request for the deadly physical force charge because defendant didn't satisfy the subjective requirement, and two, the evidence demonstrated that defendant could not reasonably fear that the victim was about to use or was using deadly physical force against him when he was lying on the ground, incapacitated and unable to get up. I just would like to point out that while it's true the bus driver said that the victim was attempting to get up, in the very next answer, I believe in his testimony, he said that the victim was unable to do so, and he remained on the ground in the fetal position. If there are no further questions, I will just ask that you affirm.
Any questions, colleagues? Thank you.
Your Honor, just just briefly, respondent mentioned in passing that the idea of another felony conviction. I just want to be clear that Mr. Kareem has no prior convictions. This is a person who is about 60 years old at the time of this trial. So he had already served the sentence for both the misdemeanor charge down and for the e-felony that was not requested. And for the reasons I argued in the primary part of the argument, there is no viable strategic reason not to ask for the para lesser, and we would ask the court to reverse. Thank you.
Thank you. Okay, finally, we have the Eisenberg case, Eisenberg versus Rem, Eisenberg versus Weisbecker. Okay. Appellant, you have 6 minutes.
Your Honor, this is Bruce Letterman for the respondent. The appellant.
Yeah, what happened to Mr. Kolko? Yeah, we've been having trouble with him making, he's had technical trouble almost from the beginning of the afternoon. Is there any way that you have to reach him?
Yeah, I've been emailing with him, and he told me he had fixed his problem. I will try again right now.
I will give him a couple of minutes because he has been trying.
Yes, I know.
Yeah. I don't even think we have any more clerical staff on our virtual thing. Let me see.
Justice Gish, I do see a 914 number. Muted. I wonder if that's him.
It is muted.
You see him on the chat or just?
I see him on the screen that there's a 914-380-2403 number, but it's muted.
I think that's him.
Yeah, he could just unmute himself. Can you hear me, counsel? If you can unmute yourself. We don't necessarily need to see him. We just want to hear him.
Right.
Oh, boy.
I don't even see him on my screen. I don't see the number.
I see him.
I'm emailing him right now.
Okay, thank you so much.
If I have your permission to use a cell phone in the courtroom, I'll call him.
You have much initiative.
I've been yelled at by Judge Oing for doing things like that over the years, so I gotta be careful.
Oh, come on. Oh, come on.
All right, I've probably been yelled at by Judge Mendez too. It's not just you, Judge Oing. Hold on, let me call him. There he is.
It's a new world, right? We're all
Yeah.
learning how to function virtually.
I actually believe that happened once. Actually, it happened once when my officer was yelling about using the cell phone. It was my cell phone that was going off. That was
Hi, it's Chris. We are on with the court. They are looking for you.
I know, and I can hear them. I used to see them because I was on the live stream, and I have the phone number on my cell phone that I'm listening to, so I can hear everybody. I guess
That's
Oh,
the 914 number.
Judges,
we can hear you through Mr. Lederman's
I put
cell.
my cell
Can you leave
phone
it on and we'll listen to your argument?
So if you'd like, go ahead.
Yeah.
Yeah, go ahead, Mr. Kolko.
Thank you, Judge. I have been back and forth with some of the clerks there all day.
We saw.
I thought we had it fixed, so I apologize for all this.
You don't have to apologize. We saw you struggling all afternoon, so go right ahead. We're all ears.
Okay, I'm glad I can get through now, Judge. Thank you very much. Good afternoon, Your Honors. My name is Daniel Kolko. I represent the plaintiff appellant in these matters. This court held in Don versus Singer that a law sharing provision was not required to create a joint venture where the parties had no reasonable expectation of losses. And this court's earlier Kobla decision had a similar hope. On this record, the guarantees relied upon by the lower courts do not reflect the actual and real expectation of possible losses here. Respondents' email to appellant, which is in the Rem record at 140 and the Weisberger record at 42, sent a day before the joint venture agreement was entered into, tells the appellant that if we paint and polish the floors of this apartment, which was bought for $205,000, we could sell it quickly in a few months for $325,000 in a, quote, very strong market, close quote. This representation belies utterly any expectation of possible loss. Respondent also said in the email, I believe we can easily make 15 to 20% annual return on this investment. This also unquestionably belies any expectation of loss.
Well, does an optimistic belief that you're going to make money belie a possibility that there could be a loss?
In this situation, yes, Judge. And I'm going to get to that because the respondent had significant experience in the purchase of foreclosed co-ops in Manhattan and their resale. He said that he had at least 15 years of experience and knows all the auctioneers. That's in our brief at page 2 to 3.
But counsel, this is Justice Moulton. I'm sorry to interrupt you, but he's not clairvoyant. What if there'd been a Superstorm Sandy? What if there'd been some, God forbid, terrorist action in New York City? This is real estate. Facts on the ground change, and a prediction of great profit on one day can just fall to pieces with some supervening event.
But not in this case, Judge, because the co-op was bought at auction for $205,000, and within a month or two, Mr. Rem, the experienced real estate investor, was telling my client, we're going to make at least $325,000 on this in a few months. So
let me ask you another question. If they didn't think that there was any possibility of loss, why did the contract provide for Mr. Rem to guarantee that your client would not have a loss of his initial investment?
Because this was part of Mr. Rem's charm offensive to entice the appellant with a smaller guaranteed money-making deal so he could get more of appellant's money to do other bigger deals in the future. Mr. Eisenberg's affidavit said that he was constantly asking Eisenberg for money for other properties. And by his boasts and pledges, okay, Mr. Rem was telling Eisenberg, this is a no-risk deal. Why? Because Mr. Rem is an experienced investor in this particular field, and he knew. And so he gave guarantees because he knew there would be no possibility of loss, and he wanted to entice Mr. Eisenberg in future deals. These guarantees, Your Honor, had nothing to do with possible losses. And at the very least, there are fact questions involved and the expectation and what these pledges and guarantees really meant. Now, I would also add that this defense was not raised in the answer, in Mr. Rem's answer. It was not raised. Had it been raised, okay.
Well, why does it have to be raised? It's not an affirmative defense. It's not an affirmative defense. It's a thing, you know. It's either a joint venture or it's not. I mean, I believe you still have your breach of contract. Nobody's claiming it's not a contract. Or maybe they did, but it's still, the breach of contract is still part of the case, right?
I think under 3018 of the CPLR, Judge, anything that could take the other party by surprise has to be pleaded as an affirmative defense. And
only on which you have the burden of proof.
Well,
an affirmative defense is something you have the burden of proof. So you know, if you're claiming that the relationship is a joint venture, then you have to prove it's a joint venture. Otherwise,
I'm sorry, we're having phone trouble here.
Yeah, no, that I understand. I'm not sure I agree with your proposition about whose burden it was here.
Well, had he raised this in the answer, it would have been a major focus of discovery. As it was, we were hit with it when the motion was made, and that's unfair. We don't have his deposition querying him intensively about why he made why he gave a guarantee. And if you look at all the other deals that he was proposing, which he said, I anticipate you will make 15 to 30% of these type of deals with full security, he was telling him there's no loss in these type of deals. There's no loss because there couldn't be a loss. Because, in fact, Judge, this was a concluded transaction which yielded a gross profit of $152,000. So under this court's PFG case, which we cite in our brief, where there is where the elements of a joint venture are otherwise present, and there's a concluded transaction which results in profit, the lack of loss sharing is not an obstacle to enforcing a joint venture. That's PFG, plain and simple. There's no other rationale or reasoning in PFG other than we have all the other elements and it's done, you made money. So it's a little bit incongruous to look after the fact and say, well, it didn't have a loss sharing provision, but where the transaction was profitable. So these guarantees had nothing to do with possible losses. And if you analyze the emails and my client's affirmation, which stated, based on what Rem told me in his email and in conversations, he thought that the prospect of a loss was inconceivable and the prospect of a substantial profit, an imminent, large, substantial profit was a certainty. Now, that's not rebutted in Mr. Rem's reply. Mr. Rem only says, well, anything can happen. That is not enough to decide this case on summary judgment.
Okay, thank you.
Also, if I have some time, I just want to get.
Yeah, you're actually out of time. I was generous to you because of technical difficulties, but you're more than out of time. All right, so let's hear from Mr. Lederman.
Well then, Judge.
Good morning. This case is and should be simply a breach of contract case. Mr. Rem is fully prepared to defend the breach of contract case in the proceedings which are still going on before Judge Lebedev. The only issue on this appeal is whether a breach of contract claim can be expanded into a breach of fiduciary claim to allow plaintiff to seek $500,000 in damages on a $295,000 claim. That's in the record at page 27. And assert claims against Ms. Rem's wife for aiding and abetting breach of contract. This court's decision in Slavicus, which Judge Gish was on the panel of, is directly on point. And that case is cited regularly. In fact, yesterday, while we were on on Zoom today, a judge in Kings County cited it. It wasn't on Westlaw last night. It came up today while I was sitting here just shepherdizing the case again. Slavicus stands for the point, which is cited by the federal courts and cited over and over, that you have to have losses to have a joint venture for the purpose of applying fiduciary duties. Even if it's not a joint venture for purposes of applying heightened standards of fiduciary duties, it's still a contract and it's going to be litigated. Two very well-respected judges, Judge Crane and Judge Lebovitz, saw that and wrote reasoned decisions. None of the cases cited by the appellant in any way have a case where there was a guaranteed return of money on one side, which is inconsistent with a joint venture. In fact, counsel referred to the Dove versus Singer case for standing for that position. It doesn't. In fact, Judge Scarpula and this is at page 17.
So counsel, this is Judge Joyner. So how do you respond to the appellant's counsel's argument that this was a win-win, no-lose situation, and that's why the guarantee is meaningless?
I have about 1,000 clients in real estate right now who will tell you that no matter how much you think something is a win-win, it's not guaranteed. I believe when Judge Moulton said it, I was I had that in my notes to say the same thing.
You're looking at his notes. Shame on you.
And anybody who's, and the truth, I submit the truth is that for somebody like the appellant to be saying that I thought there was no possibility of loss, that shows why this is not a joint venture.
He didn't say no possibility of loss. He says no loss at all. He said there was going to be no loss at all.
The cases from this court do not support that. Like I said, Slavicus is directly on point. If there's no possibility of a loss, it's an enforceable contract, and he bargained for a guarantee. And he may say now the guarantee is meaningless, but why didn't he say that when he was negotiating the contract? He could have said, I don't want your guarantee, it's so good. He took it, and all that means in the context here is that he can't pursue Mr. Rem's wife in what I submit are probably frivolous claims of aiding and abetting breach of fiduciary duties. He wants
well, if there's no fiduciary duty, then you can't aid and abet. But you might have a tortious interference with contracts. So let's look at that for just a little bit. A lot of the things that are alleged are before the contract is even made with your client, Mr. Rem. So those don't fall in tortious interference with contract. But then the apartment is sold or is retained by the estate and not sold. And let's assume it's for tax purposes, although I think that's probably a legitimate purpose. But why isn't that? And she knew about the contract that her husband had with the plaintiff. Is that a tortious interference with that contract, that she held property that the estate owned for estate tax purposes?
No, because, for example, I can sign a contract to sell you, Judge Gish, the Empire State Building. There's nothing tortious about that. It may be a breach when it turns out I don't own the Empire State Building, but Mr.
That's in the contract with Rem. But
Correct.
The question is, did she interfere with his performance under that contract?
No,
and you're saying he never owned the property anyway, so what could she do to interfere with it?
Not under the standards for tortious interference with contract. You have to allege more than just his wife was aware of it or his wife was a lawyer. Otherwise, every lawyer in the state would be guilty of tortious interference with contract.
Well, those are two elements. There's more to it, but yeah, there's more.
They just don't meet, and there has to be knowledge and an intention on her part to interfere. This was something that her husband did, and it's a breach. If it is by him, I believe the courts, otherwise, pretty much any lawyer could be accused, if you expand the standard of that, for any case of tortiously interfering with contract, because effectively the only thing he's saying she did was she acted as his lawyer in it. And so I don't think that supports in any way a claim of tortious interference, because
I thought he said more than that. I thought he said that because she controlled the property through her father's estate, that she held the property off the market rather than sell it for a quick profit, which is what they intended under the contract with Rem.
In the case that in Mr. Rem's case, which will go to trial, what the facts will be established is that this was a co-op and there was a problem getting board approval. That's why Mr. This was in our papers.
Father-in-law.
When the father-in-law died, the co-op had to approve it. That's why there were delays. That's why Mr. Eisenberg asked for his money back, got his capital back. He's fighting over the profits now, which Mr. Rem will show were paid from a different transaction. But there's no actions by Ms. Weisbecker here that could support a claim of breach of tortious interference with contract. And I'd like to conclude by just pointing out that Justice Cardozo's landmark decision, Meinhardt versus Solomon, which is the case that everybody talks about the punctilio of honor most sacred, one of the factors he considered there was a sharing of losses. This court's decision in Slavicus follows what Judge Cardozo wrote. This court's decision continues to be cited as the law. This court's decision as recently as Friday in Kings County was used to dismiss the extraneous claims and allow the courts to get to the heart of the decision. And for that reason, I submit this court should issue a decision reaffirming Slabicus and affirming both Judge Crane and Judge Lebovitz. Thank you, judges.
Thank you. Mr. Colco, you have rebuttal. You still with us?
Judge, first, yes, yes, ma'am. Slabicus is totally distinguishable. In that case, the complaint itself alleged clearly that the losses were all to be absorbed by the defendant. The complaint clearly stated that the management and control was solely...
Isn't a guarantee that you won't have losses, isn't that the same thing? I mean, it's a functional equivalent, isn't it? I guarantee you won't have losses. I will absorb all your losses. What's the difference?
No, there was no guarantee in Slabicus.
Didn't have to be. One party was going to absorb it. In a way, the guarantee makes it stronger that it's not a joint venture. You will never have any losses.
Well, Your Honor, in Slabicus, the complaint itself negated two key elements of a joint venture. We don't have that in our situation. Number three, Slabicus did not involve, in the opinion, I can't speak for the record, Slabicus had no discussion of the burning issue in our case, namely expectation of loss and what it means and what it doesn't mean. Slabicus is a run-of-the-mill joint venture case.
But don't you have to, as you would any other agreement, don't you have to look at the four corners before we start looking into people's minds? I mean, it's unambiguous on its face, isn't it? What they had, that there was no sharing of losses?
You broke up. I'm sorry, Judge.
I'm just, you're saying we have to find out what did they intend, what did they look at? Why do we go that far? Isn't it evident on the face of the document what they intended?
No, because if Mr. Rem gave a guarantee because he knew 100% in his heart, because he's 15 years in the business, he knows the market, that's his life, and that's his life. Knowing the market, knowing how to time the market and what things are worth. He knows, and he's buying this at a distressed price in auction from a foreclosed tenant for $205,000, where a month or two later, he is so confident of the price and the market value that he is telling my client in his famous email, we could get at least $325,000 for this. This is a mere 2 months after they bought it at auction. So how can you possibly say that at least in the mind of Mr. Rem, that there's any possibility of losses? In his mind, there was no possibility of losses. He wanted this fellow's money for future deals. He wanted him to feel good, and he gave him a guarantee which was worthless. It didn't mean, it had no meaning. It may have made Mr. Eisenberg feel good, but in terms of substance, it had no impact, it had no meaning. And it just simply showed not that there was a real possibility of losses. The guarantee showed the opposite. There was no possibility of losses, and that is why he gave him the guarantee, and that is why he was going to give him guarantees down the line with no loss, according to his email. His email shows his mindset, Judge. And the mindset was, we got it made here. Now, PFG, this court's PFG holding is conclusive. PFG says that when you have a joint venture which leaves out the loss sharing, it's not consequential if the transaction has concluded successfully. Well, this transaction concluded successfully, at least for the respondents, not for my client. He got gypped out of his share of the profit. So
maybe not. He's going to still pursue his breach of contract. Okay. I think we understand your argument, Mr. Colco. You're out of time at this point. But I thank you both. An interesting argument.
If I may? I'll be 30 seconds, Ben.
30 seconds.
Thank you, Judge. And thank you for your time. I appreciate it. The fact that Mr. Rem did not raise this in the lower court caused manifest unfairness to our side. We didn't hear about this till the motion papers were served. I could have deposed Weisbecker, which I did, but I could have deposed her on this. I could have deposed Rem on this, and it would have been a focus of our discovery. What was his intention? What was his motive? And by the way, may I just point out lastly that Mr. Rem's email is New York Auction at Gmail, and his email nickname is Real Estate Investments. It's at 140 of the record. That's on the famous email. I think that is significant here. That shows that Mr. Rem was knowledgeable, prescient, he knew valuations, and he knew when he could give a meaningless guarantee to get some younger kid to cough up $220,000, which is what happened. So on this record, can this be summary judgment? There's no doubt about what the facts are here. It's replete with facts.
Okay,
so,
thank you, Mr. Coco.
And I appreciate your time.
You're way over your time now. We've been generous to you. All right, I thank you, though.
Judges, it's nice to see you all.
The appellate division is now concluded.